Mogabe, is everyone here?
Morning, Judge.
Morning. Are we all here?
Apparently so, Judge.
Judge, just to confirm, I'll be replacing Mr. Botha for Freedom of Religion South Africa under the leadership of Advocate Willis.
Okay.
Confirm that, my lord.
Willis,
Good morning, my lord.
Thank you. Good morning, Mr. Willis. Mr. Willis, do you still sit at Dumanokwe?
Yes, I'm still sitting here, my lord. Indeed so.
Dumanokwe, oops. Okay. Mr. Crompton, you in Cape Town, in Eastern Cape. Okay. Are we ready then, Mr. Mogabe? We'll proceed. Is Mr. Boda also not available today?
I am here, my lord, but I will be in and out. But my two juniors are present.
Yes. Benefits of counsel, they can go in and out as they wish. The privilege of counsel. Okay, let's proceed then with Mr. Mogabe, and then hopefully we'll get some time today for the other persons. Mr. Mogabe, if I have the same problem as I had yesterday or the day before where I get frozen, I will put my video off if that's okay with you.
Yes, my lord.
Is that okay?
No, that's okay with me, my lord.
Okay, thanks, Mr. Mogabe. Mr. Mogabe, you can continue and take as long as you wish.
As long as you can hear me, my lord.
I can hear you, Mr. Mogabe.
But if you are frozen, then it's another issue, my lord.
I will keep speaking to let you know that I'm listening, but I will put my video off.
Yes,
I hope
my lord.
that doesn't happen, but if that happens, I will keep you informed as you speak so that you are aware that I am still here.
Yes, my lord.
All right, let's proceed then, Mr. Mogabe.
Thank you, my lord. My lord, yesterday we adjourned when I was still addressing the court on the issue of mootness, my lord. Just to round off, my lord, this aspect, my lord, there was this question from the bench that as these people are complaining of a infringement of a fundamental right, doesn't that obviously, my lord, entail that in the interest of justice, even though the matter is moot, I mean, the court can still entertain, I mean, the matter. My lord, I then informed the court, my lord, that as it was decided in the Langeberg municipality matter, my lord, IEC and Langeberg, my lord, likewise in this case, it involved an infringement of a fundamental right in the form of Section 19 of the Constitution, which obviously, my lord, I mean, enshrines the right to vote. So even in those circumstances, my lord, the Crown Court, I mean, decided that as the elections had come and gone, it will serve no practical purposes, I mean, to entertain the matter being moot. So, my lord, it is the trigger of the court's discretion to apply the interests of justice does not depend on whether the right infringed is fundamental or a lesser right, my lord. I mean, the application of the test is whether, in fact, my lord, if ever the court, I mean, determines the matter, it will have any practical effect on the parties or any other persons, my lord. So in the Crown Court, I mean, even though there was a constitutional infringement of a constitutional right, the Crown Court nonetheless decided that, I mean, as the matter was moot, they're not going to entertain, I mean, the matter, my lord. And I mean, the last paragraph thereof, my lord, it's instructive, my lord. Normandine, my lord, I just want to put on record, my lord. Normandine citation is, my lord, Normandine Farms Pty Ltd. And the South African Agency for Promotion of Petroleum Exportation and Exploitation Limited versus Rhino Oil and Gas Exploration and the Minister of Mineral Resources. It was held on the 26th of November last 2019, and the decision was delivered on the 24th of March 2020. That is last year, my lord. It is basically what it means, my lord, the latest case on mootness by the highest court, my lord, in the land, my lord. So basically, it is, I mean, the latest binding case on that, my lord, and the court, in any event, will be bound to follow Normandin. We submit in this case, my lord, in dealing with the matter, my lord. My lord, I mean, the last one, which I have already said in Langeberg, my lord, last paragraph thereof, my lord, it is the Langeberg case, my lord. It is cited in the heads of all the parties, my lord. Independent Electoral Commission versus Langeberg Municipality, my lord. I just want to read the last paragraph on paragraph 14, my lord, which reads, having said that, a determination of the condition precedent will turn on the facts, as the disputes between the parties are moot, and as future cases, because that's what was, I mean, submitted, as future cases might present different factual matrices, it will serve no purpose, I mean, to resolve them. What is also instructive, my lord, in this matter of Langeberg, my lord, it's the footnote 10, my lord, in Langeberg, my lord, which is deals with the issue of mootness. In footnote 10, I mean, the court, per Yakub J. and Malanga J., my lord, referred to a extract from Charles Carson et al. Constitutional Law of South Africa, Revision Service 2 at 8, paragraphs 8 to 16, footnote 10 of Langeberg, my lord, to the following effect. Mootness will be a possible bar to relief in constitutional cases where the constitutional issue is not merely moot as between the parties, but is also moot relative to society at large, my lord. So, I mean, on the basis of that, I mean, society at large, my lord, I mean, has no qualm with these regulations which have already come and gone, and therefore it do not even have any practical benefit to society at large, my lord. Society at large, as matters stand, are now at alert level 1, which is the highest number allowed in relation to faith-based gatherings, my lord. So, my lord, that being so, my lord, I would submit, my lord, that we have made out a case on mootness, and that even if the court, I mean, will have to apply its discretion, we submit that, my lord, it will serve no practical effect or useful purpose to deal with the dispute of the matter. Basically, as it was said, my lord, in this case of Langeberg, the disputes are moot, and future cases, as a future case might present different factual matrices, my lord, it will serve no useful purpose or practical purpose to resolve, I mean, or entertain this matter, my lord. And as such, my lord, on that score, on that basis, my lord, the application, as was done in Langeberg and Normandin and the other case you cited to your lordship, falls to be dismissed, my lord. This then will entail, my lord, that there will be no need, as was said in Normandin. The court then said, after it had found out that, in fact, determined that the matter is moot, that there was no need, my lord, to deal with any other issues raised, I mean, by the parties, my lord. So, my lord, on that score, my lord, we submit that once the court comes to a finding that the matter is moot, then there will be no need for the court to deal with any of the other issues or delve into the merits of the matter. That will be, as they say in Latin, cedit quaestio, my lord. However, my lord, if the court, I mean, is of the view that it is not so, my lord, then obviously then I will then have to traverse the merits of the matter. My Lord?
Yes, I'm with you.
You're with me, my Lord?
Yeah.
Yes, my Lord.
Am I not visible on the site? I'm busy looking at your heads in on the screen. I'm sorry. So that's why you don't see me doing anything, but I'm typing here, so I'm
Yes, my
looking
Lord.
at your heads. Okay, but so now what do you want me to do? Do you want me to make a decision on mootness first? Or do you want me to, are you going to continue with the rest of your argument and say why, in any event, even if this court finds it is not moot, your client should still succeed?
Yes, my Lord. Well, my Lord, I mean, if the court is inclined, then maybe the court then maybe can have to give a ruling, my Lord. I don't know how to.
You
No,
need to give a ruling first.
I'm not sure, my Lord. I mean, your Lordship's hands.
No, I think the way the case has been argued, the merits has been, the mootness point has just been dealt with as one of the points. I think the applicants are aware that they may lose on mootness, but have presented the rest of their case on the presumption that, not on the presumption, but on the assumption that if they they succeed on mootness, the rest will be then dealt with. And I think the same should be applied in your case. If we come to the conclusion that the matter is moot, then all of those arguments will just fall away. They'll just not be dealt with. They'll
Yes.
just not be decided. The issues will just not be decided. That's how I believe the matter should proceed. I don't know if any of the other counsel take a different view of it. I can ask them, but I presume there's no need to, because that's how they presented their case.
Indeed, my Lord. Indeed.
Unless any of them have a different view, they can just raise their hand now.
My Lord, we don't have a different view. Nevertheless, if the court were to want to make a ruling on mootness, then we would ask for a right to reply to my learned colleague's submissions.
No, obviously.
So to be honest, I think for the sake of time and not delaying this matter any further, if my learned colleague can proceed to deal with the other issues.
I think that's the approach we've adopted ab initio from the beginning. I think
Yes,
we
my Lord.
just proceed with the same process we've adopted from the beginning. Mr. Mukhagabe,
As the
continue.
court pleases, my Lord, I will then, I mean, I will not belabor the matter, my Lord. The matter is in your Lordship's hands. I will then, my Lord, I mean, proceed to deal with the merits of the matter, my Lord. My Lord, however, my Lord, prior to doing so, my Lord, I submit that it will be apposite for us, I mean, to put into context the manner in which the regulations were made, and the reason why the regulations were made, and the manner in which, I mean, the context within which the minister and the government responded to this pandemic, my Lord. My Lord, as such, this is contained, my Lord, which I want to read into the record, my Lord, for context purposes, as well as to demonstrate the minister's approach and handling of the pandemic, as well as government dealing with it, my Lord. Its response to the pandemic, my Lord. This is set out, my Lord, in the minister's answering affidavit, which is contained in the FOSA matter, my Lord, at case lines 009-1
Yes.
to 001-279, my Lord.
009-1
under the FOSA matters, my Lord.
Yes.
FOSA case line.
Yes, I've been directed to it.
As a court, please, man. Thank you, my Lord. I
Now,
will.
Mr. Mokharabe, just before, I don't know, there's been a number of different answering affidavits. I tried to go through as many of them as I could. There seems to be the same argument in all of them, but I can't say that there is a different or more of an argument rather in one of the other ones or not. Could you be able to tell me which is the answering affidavit that's best to focus on? In other words, that canvasses all the issues.
Well, my lord, I mean, I from my reading of the papers, my lord, it appears that the answering affidavit follows, I mean, the same format in all four matters, my lord.
Right.
Yes, I think, especially with regard to the issue of the overview, my lord.
Okay.
Where, in fact, my lord, is different, then I will have to obviously direct the court as to which, I mean, affidavit then encapsulates almost, I mean, everything, my lord.
Okay. Continue, Mr. I'm with you, Mr. Mokharabe.
Okay, my lord. My lord, the overview, my lord, is contained in this affidavit, my lord. If there's any need, my lord, to that effect, I should obviously direct your lordship to other affidavits which have a different information. I'll do so, my lord. But in essence, my lord, I just want to show that, my lord, in fact, I mean, what the overview of the minister relating to, I mean, the pandemic and the promulgation of the regulations, in other words, government response in combating this pandemic, my lord. My lord, if I may direct your lordships to 009-8, paragraph 4, 14.8. My lord.
I'll get there. I'm there.
Yeah, it says the applicants are abusing the court process by seeking reasons. I just, my lord, for the sake of time, I'm not going to start where it starts, where it sort out. I mean, it sets out, I mean, a chronology of the relief which is sought by the applicant. Just want to start where, in fact, the minister deals with regard to the overview, my lord. 14.8 says the applicants are abusing the court process by seeking reasons sought for regulations permitted under alert level 1 and alert level 3 in circumstances where the regulations have been amended and replaced by the general regulations. In any event, the applicants are not entitled to the reasons sought, as these are executive in nature and confidential. Legal argument presented to the court. Then 14.9, my lord, having regard to real scientific data, reduction in infections, views expressed by relevant cabinet members, and the need to open the economy. My lord, the DMM regulations have been amended from time to time. My lord, you remember there was this submission made that, in fact, the minister was not motivated by any economic imperative, but it is here that is set out that, in fact, I mean, also with regard to the need to open the economy, that the regulations.
Do you see the lives and livelihoods argument as being the same as that?
I beg your pardon, my lord?
The lives versus livelihoods argument, as I have just been using it in here.
Yes, my lord.
Has your client brought that case forward? Is that your client's case?
Yes, my lord. I mean, it is made in the papers.
49 is saying.
Yes, that is made in the papers.
Hmm.
That is obviously, my lord, that I mean, the objective and aim is flattening the curve, as they say, or curbing the spread of the virus, was to save lives and livelihoods. That is obviously, my lord, I mean, the predominant, I mean, principle that directs, I mean, the promulgation of these regulations. In other words, government response in dealing with the pandemic, my lord. Then, my lord, we move to 15.3. Although the applicant asserted legality in his founding affidavit, a case has not been made for a review under legality, my lord. I will then, my lord, find you, I mean, whilst my juniors will find the reference to where, I mean, the respondents say, I mean, this was obviously, my lord, I mean, predicated or motivated by the desire or intention on the part of the government to save lives and livelihoods. In other words, in applying the risk-adjusted strategy, my lord, the government, the motive behind there, or the reason was basically, my lord, to flatten the curve, spread the curve of, curb the spread of the virus, basically to save lives and livelihoods, amongst other reasons to do so, my lord. Hence, obviously, my lord, depending on the, if I may submit, my lord, depending on the scenario on the ground, relating to the spike in the number of infections, the ability and capacity of the health facilities to cope with the infections, i.e. the hospital admissions as a result of the infections, my lord, and in both private and public hospitals, and the spike in the number of deaths, and etc., my lord, then the government determines adjusting the alert level. The adjustment of the alert level, my lord, is not a mechanical, my lord, conduct on the part of the government and the minister. It is informed, my lord, by, amongst others, these factors that I've done, as well as, my lord, dealing with the on the advice and recommendations of the NCCC, my lord, the National Coronavirus Command Council, my lord.
Now, is it based on the advice and of the NCC?
I think it's my lord, I think the advice of the recommendation of the National Coronavirus Command Council and the input, my lord, of the Ministerial Advisory Committee. This, my lord, is set out, my lord, in the same affidavit, my lord, where it says the 00 case line 009 -9, paragraph 15.6, my lord. The applicant has failed to make out a case for an order compelling the production of a record in respect of Regulation 36.3 and Regulation 84.3 of the General Regulations. In this regard, it is significant that the decision underlying these regulations are taken by Cabinet on the recommendation of the National Coronavirus Command Council, a committee of Cabinet. The record of these decisions is thus confidential. Then, my lord,
I'm with you, Mr.
The next page, my lord, 009-10, paragraph 16. My lord, paragraph 16. Yes. I should also add that the prohibition on faith-based gatherings, my lord,
yes,
is under constant review, particularly in light of decreasing daily infection rates. If and when Cabinet deems it safe to do so, the prohibition will be lifted. I undertake to advise this court as soon as the change in Cabinet's approach to the prohibition. Then he goes on and says, in any event, I contend that the applicant has failed to demonstrate that the current restriction on faith-based gathering unjustifiably limits its members' constitutional right. As demonstrated, any limitation is reasonable and justifiable. Then, my lord,
probably on 16, this is the issue. I know I'm going to ask the others whether I can take judicial notice of this fact. What is different that has happened, and you've spoken about it very briefly yesterday. What is different is that since the promulgation of these regulations, vaccination process was commenced with.
Yes, ma'am.
And yesterday, when you spoke about factual matrix, you said that's going to be a key factor in future decision making.
Yes, my lord.
You said that yesterday. Now, what I didn't, when I looked at your supplementary answering affidavit yesterday, I saw that I could not find any reference to this. Do you not think it was necessary for your client to put this up and say that there has been now more vaccination, the process is undertaken, and how far it's going?
With regard to
And
the
how
issue
this
of
impacts upon her future decisions.
with regard to the issue of the
Well, it might become part of the mootness argument. It might. I don't know yet.
yes, the issue of the vaccination.
Yes. Your case is, if I remember mootness, you just said something about a new factual matrix.
Yeah, I say, my lord, I say, amongst others, my lord, that the new factual matrix may inter alia be that if ever the regulations are imposed again, right, that it may not be in the same shape or format or wording or total prohibition as it is now, my lord. It may come in a shape, form, or format totally different from the ones we are dealing with, my lord, as set out in the impugned regulations. And that, my lord, that would not only be, my lord, informed by the factors I have already alluded to the court, but also having regard to the vaccination rollout program by the government, right, which may also, my lord, be relevant with regard to the reduction in the infection, my lord.
Now, what I'm asking is,
and therefore that will then inform, the terms of the regulations, my lord.
Yeah, but now, why in 16, if your client says that she's going to undertake to advise the court as soon as there's a change in Cabinet's approach, and on that basis, your client files a supplementary affidavit, which everybody says has to go in, why was she not dealing with this point?
Yes.
Is there any reason why she didn't put this in her affidavit? Mr. Mokakabe?
Sorry, my lord. I think, as I understand, was that the fact, maybe the reason why it didn't go into paper was that maybe we didn't want to raise new matters, and then the other side might say, no, in fact, you are raising new matters, and take obviously objection to that. But I did ask the court that the court can take judicial notice thereof, man. Yes.
And do you say it's a notorious fact?
Yeah, I think there is allusion to, if I'm not wrong, in the papers, my lord, to the vaccination. I just that I left maybe to check, my lord, on that aspect.
Okay, we'll do that as we go along. Thank you then.
Yes. Yes, my lord. My lord will also have to take into account that, my lord, one of my handicaps is that I was not involved in the drafting of the papers and the heads. So I only came here because the counsel who was previously involved had fallen out, Ms. Kameshni Pillay, my lord. So maybe that might be the reason why you have to look at it again, my lord. But be that as it may, my lord, may I move on, my lord?
Yes. Yes.
My lord, then I move on to 5, 3, 4. Okay. To paragraph on 009-12, paragraph 22.3, my lord. It says 22.3. On 29 December 2020, as a consequence of the second wave, which I elaborate upon below, alert level 3 became operational in terms of government notice R143 of 28 December 2020. Alert level 3 makes 2 substantial alterations to the movement of persons. 22.3.1. First, Regulation 33 as amended confines people to their homes between 2100 hours and 0600 hours daily. Second, Regulation 36.3 prohibits all social gatherings, including faith-based gatherings, are prohibited for 2 weeks, after which this provision will be reviewed. Then say on 11 January, the regulation was amended and Regulation 36.3 was replaced with the current version, which prohibits all social and faith-based gathering, my lord. Then, my lord, I move on to paragraph 30, my lord, on 00914. Faith-based gatherings are not under complete and indefinite ban. The declaration of justice level 3 is temporary. The NCC and cabinet are constantly monitoring the situation with a view to adjusting alert levels in order to ease, restrictions, my lord. Then they say, my lord, at 31, the general regulation was promulgated in response to the second wave of infections, which was driven by the new variant. You see that, my lord? That's the reason that resulted in the promulgation of the general regulations. The prohibition of social and faith-based will only last until the NCCC and cabinet, after conducting a thorough risk analysis, my lord, and advised by the Ministerial Advisory Committee on COVID-19, decides that it is appropriate to change alert levels, my lord. And that, my lord, I may interpose, happened on the 1st of February this year, when the regulations were promulgated, in terms of which the prohibition contained in the January regulation was uplifted. So those basically are basically the factors or reason that determine, or which government relies on to adjust these alert levels, my lord, in applying the risk adjusted strategy. It is not like it's a mechanical automatic conduct, arbitrary one, as I want to put it, my lord. It is informed decision by various factors, particularly if there's a drop in the number of infections, my lord. My lord, then I move on, my lord, to 009-15, where at paragraph 34, where it is said that juristic entities like FOSA do not have the right to freedom of religion. Paragraph 35.
But what does that mean, Mr.?
Well, my lord,
we recognize that individuals have a right. We recognize that the applicants in Ms. Martin's case, all those applicants have a right to freedom of religion. For some, maybe an advisory committee, it may be a lobby group, if that's what your client's saying, that may be so. Whether it does or doesn't, we can debate that. But it's not going to take the matter any further.
Of course, no, my lord.
We already know there are applicants before court.
Of course,
they have a right to religion. And those people have, and these organizations anyway have members who have a right to religion, and they're acting for and on behalf of their members.
Yes, my lord.
So we have to accept that the challenge is based by people who are properly before court and who do have a right to freedom of religion. That, I think we have to work on the premise that that is established and we move on and then consider the issues from there.
Yeah, my lord, this is just a statement of law relating to, juristic persons, because as you say, my lord, FOSA is a legal advocacy group which says that it represents a large constituency of faith-based institutions. Yes.
But we accept that Ms. Martin's clients clearly have, or some of Ms. Martin's clients clearly have the right. We also accept that some of the members, the members of the Mr. Boda's clients all have a right, and Mr. Boda acts for and on behalf of them. We also accept that Mr. Boda has brought forward 2 or 3 individuals, I think, There may be applicants who said that they were personally affected when they tried to exercise their right to freedom of religion by going to a mosque and were basically thrown out and were physically mishandled, etc.
Yes.
So the issue of the right to freedom of religion is no longer an issue here. We have to accept
No,
it is established by the applicants that that right is in question and that they have and that they are fully entitled to exercise that right as applicants before this court.
of course, I'll accept that SANC, the second and third applicants in the SANCF matter, my lord, do have the right to religious freedom, my lord.
Yeah, and so in that
That is
case,
accepted.
whether FOSA does or doesn't is really irrelevant. They are here, they have every right. They've been admitted, they can argue what they have to, they're entitled to do so. So we will work on the premise, as we should, that the right to freedom of religion has been established. And that the litigants have established established the entitlement to rely on that right.
Yes, my lord.
Mm.
My lord, that is accepted, my lord.
Right.
It doesn't, I mean, what was made here, put here was just a statement of the law, I mean, relating to juristic persons, my lord, of which obviously FOSA is, but it says it's a legal advocacy group which represents, I mean, a large constituency of faith-based institutions, my lord.
Mm. Thank you. Excuse me. Thank you, Mr. Mohabe. You may continue.
Thank you, my lord. Thank you, my lord. Thank you, my lord. We're not going to belabor this argument, my lord, whether in fact AfriForum or Solidarity Aid has the right to freedom, but I mean, we'll argue the case on the basis that maybe the members that the people that they represent have a right to this religious freedom.
Correct.
Yes. And then I move on to paragraph 35, my lord. In any event, as stated above, the prohibition of faith-based challenges is not permanent. During alert level 5, 4, and 3, the prohibition of faith-based gathering was part of regulated or promulgated with the intent to flatten the curve of infections, my lord. My lord, I may pause here to say, in respect of level 5, 4, and 3, my lord, so religious gatherings were also, I mean, totally prohibited, my lord. Yes. So it is not like, my lord, I mean, and at that time, it appears.
3. Let me just bear with me.
Yes, my lord, also 3.
Also 3.
Yes, also 3, my lord. The restriction started to be lifted when it came to alert level 2. And I think, I mean, the number of persons was allowed up to 50, my lord, maximum of 50. Yes. Even then, my lord, the applicants didn't complain. Nor did they complain about alert level 5, 4, and 3. It seems they accept the rationale behind the imposition of levels 5, 4, and 3. And if so, my lord, it is incongruous that they would then complain about the restrictions in terms of the December regulations and January regulations, which in any event also prohibited religious gatherings, my lord. My lord, if you look at alert level 3, my lord, as I understand here, my lord, is alert level 3, from 1 June to 17 August. Religious gatherings or not more than 50 persons were allowed subject to the health protocols, my lord. and the conditions outlined in the directions.
So just so level 3, yes, I'm a bit confused. Was it allowed or was it not?
Well, according to the schedule of regulation, it appears it was allowed.
It was allowed.
Last year, my lord.
Yes. Are you looking at the schedule that's annexed to your supplementary?
Yeah, 031-13, my lord.
031-13. Yes. So it was allowed in level 3.
Yes.
So it's 4 and 5, it's not allowed.
4 and 5 not allowed.
Right. So 3, she's wrong. In paragraph 35, she's wrong. She says, in any event, the prohibitions on faith is not permanent. During level 3, the promulgations, the prohibition.
Yeah, it seems, my lord, I mean, it's an erroneous statement that 3 was also involved. I think it's 5 and 4.
Yes. It's only 5 and 4. Okay, thanks.
Yes, my lord. And then it says, under alert levels 2 and 1, the prohibition was removed and restrictions were put in place, my lord.
Right. Thank you.
My lord, I see Ms. Engelbrecht wants to intervene, my lord.
Sorry, I'm not watching. Thank you for bringing it to my attention, Ms. Engelbrecht.
My lord, I thought I could just be of assistance to the court. The adjusted alert level 3 did make provision for prohibition as well. So, as it were, against myself, I just want to assist Mr. Mogabe to just point out that level 3 did, in its adjusted form, include a prohibition.
And that's the December and January regulations are called now adjusted level 3.
That is correct.
In other words, the descriptions have never been fixed and steadfast. I mean, they seem to move themselves. Within them, you may sometimes have slight differences. Within, I mean, 5 we've never gone back to, and I hope we never will. And everybody hopes we never will, because she says herself in her affidavit that there's a serious concern of trying to get the economy back on track. So 5 hopefully we'll never go back to, because it's really closed down the economy as well. But during 4 and 3, there seems to be sometimes some adjustments here and there. They don't seem to be absolutely identical each time they impose a 4 or a 3, especially a 3. But you're right, during adjusted level 3.
I simply wanted to assist Mr. Mogabe.
Thank you.
That
Thank you, Ms. Thank you,
Well,
Ms. Engelbrecht.
I wanna thank Ms. Engelbrecht, my lord, for doing that. I hope obviously not be too these clients will not take any umbrage to that, my lord. But it was for the benefit of the court too, my lord. So as to put the whole matters into correct perspective, my lord. So she is right, my lord, in paragraph 35. Yes.
Yes, except that she forgot to mention the word adjusted.
Yes.
Alert level 3 and alert level adjusted and adjusted alert level 3 are not the same.
Yes, my lord.
It's a different category now.
Yes, my lord. If my lord, you can recall, the December regulations were referred to as adjusted level 3 too.
Yes.
Yes. Which were promulgated after adjusted level 1 last year, my lord, in December.
Thank you.
Yes, my lord.
Thank you, Mr. Mogabe.
So it seems that obviously it's a tweaking of the alert levels, my lord, in respect of the prevailing situation on the ground, as say adjusted, my lord. Thank you, my lord.
Right.
My lord, I mean, and then proceeding in terms of this paragraph 35, then it says under alert levels 2 and 1, the prohibition was removed and restrictions were put in place. With the advent of the second wave and the new variant, a review of alert level 1 was necessary, my lord. Yes, my lord. This resulted in a temporary reinstatement of the prohibition on faith-based gatherings, my lord. The point made of is that, in fact, I mean, the change to adjusted level 3, my lord, in December was as a result of the resurgent, or I mean, the advent of the second wave. I think it was called the beta variant, my lord. Yes. Hence, I mean, there was a temporary, my lord, a prohibition on, amongst other things, faith-based gatherings, my lord, for a period of 2 weeks. That's why it says 2 weeks. It was a period of 2 weeks subject to review. But then this is what has happened with regard to the pandemic, the response to the pandemic. The point is made that its prohibition is rational, reasonable, and justifiable. Then, my lord, we move on to paragraph 38 on page 00916. The point is made, my lord, that the regulators do not interfere with religious community and belief. They merely temporarily prohibit faith-based gathering in a physical setting, my lord. I will, in due course, deal with these aspects, my lord. And the way that, I mean, they do not interfere with religious convictions and beliefs. But what they do is they temporarily, my lord, prohibit faith-based gatherings in a physical setting, my lord. I will deal with this aspect in due course, my lord. It's just that I'm trying to give a context with regard to, I mean, how the minister and the government responded to this pandemic, my lord. Then he says, whether a holy text, my lord, paragraph 39, that command people to gather, it must be that these texts or the scriptures envisage exceptions to the rule in situations where it is not safe for people, obviously, to gather, my lord. In other words, I mean, these texts and scriptures do not operate in a vacuum.
Now, that question, I'm going to ask you this, which Mr. Botha was very strong on, and he quoted a number of judgments, which all seem to me to be correct. This court, as well as her, are incapable of engaging in doctrinal disputes regarding interpretation of the holy text.
Well, my lord, according to Judge Sachs, my lord, the court should, wherever possible, my lord, avoid dealing with this kind of issues, my lord.
The doctrinal disputes.
Yeah, my lord. Doctrinal disputes, my lord, and theological issues and beliefs and faith, my lord, are complex and intricate and deep-seated issues, my lord. And as Justice Pone, my lord, I think, as a matter was a judgment quoted, also said the same, my lord. I'll just, my lord, I mean, try to find it, my lord. That as much as possible, the court should not get involved in determining doctrinal, I mean, issues, my lord. But the point made is that, my lord, I mean, in any event, this do not operate in a vacuum, my lord. I mean, they're also dependent on whether it is safe for people to do so. Anyway, my lord, let me move on. Paragraph 41, same page. Any challenge to regulation have suddenly been replaced is a moot. I deny that this application is in the best interest of surrounding society. It goes without saying that South Africans are facing enormous danger as a result of the transmission of the virus. It is in their interest that the rate of transmission be slowed down and that the curve of infection be flattened, my lord. Then, my lord, it deals with 42 that the president did have consultation with a cross-section of faith-based leaders, my lord. My lord, I mean, then on 48, page 00918, then I mean, the minister deals with the fact of that the role played by the NCC and cabinet in responding to this pandemic. It says, I deny that applicants entitled to record sought in this paragraph, the deliberation leading to the making of regulations and the ultimate making of regulations are executive in nature. Furthermore, there are documents prepared for and by the NCC, a committee of cabinet as well as cabinet. These documents are therefore confidential, my lord. Then it says, because of the sensitive and far-reaching impact of time, all decisions relating to the determination of alert levels are discussed in the NCCC, which is a committee of cabinet. Subsequently, the NCC makes recommendations to cabinet. I intend to give effect to the decision of cabinet by publishing a notice and or regulation approved by cabinet. So here, in fact, he sets, out as to the basis why, this the document is confidential and privileged, my lord. That, in fact, obviously, basically, these are from, the deliberations of cabinet. So it's not like maybe the minister doesn't provide any reasons as to relating to, the documentation sought, my lord. I will also deal with this aspect in due course, my lord, when I go through my heads, my lord, relating to this aspect. My lord, then I point out, my lord, that the minister does accept at paragraph 63.00.21 that some people may be frustrated by the restrictions. Unfortunately, the restrictions remain necessary in order to slow the rate of transmission and flatten the curve of infection. And that people who are minded to disobey the law do so at their own risk, my lord. They not only do so at their risk, my lord, of flouting the regulations, but they do so at the risk of their own health, as well as the health of their families, loved ones, and friends, my lord.
And anyone else they come into contact with.
And anyone else they come into, in fact, at the risk of society in general, my lord. Yes. My lord, then the point is made about, in paragraph 64 and 65, about the consultation carried out by the president. In fact, the minister makes the point in 64 that at the, he accompanied the president and presented the proposed general regulations to, at the meeting in which the president had consulted with religious leaders on the necessary steps to combat the virus. The point, my lord, which is made about how far should the minister go, where do we draw the line, what is the criteria, is made in terms of paragraph 65, that despite our best efforts, it goes before saying that it will be impossible for all religious leaders to be consulted, my lord. Having regard to the urgency of the situation, my lord, if I may add, and the danger presented by the pandemic, my lord, it will be putting an onerous burden, even not an unreasonable one, on the minister to consult with each and every religious organization, my lord, in this regard. Similarly, my lord, to consult with maybe each and every political party or traditional council, in the country, my lord. These are also, my lord, people who are also affected by the prohibition, my lord. It's not only as if the case is made out as if the faith-based organization or the church is being targeted at the expense of other entities or activities, my lord. Other people are also, my lord, affected by this prohibition, my lord. And you can imagine, my lord, that now, if ever it is so, my lord, then it means that, my lord, the process of consulting will be done at the expense of saving lives and livelihoods. The government has to act urgently, swiftly, and speedily in responding to the virus, my lord. My lord, I'm not going to go further, my lord, to say, this issue of an aspect was raised, my lord, in argument that it seems as if this prohibition also hits the a meeting between religious leaders and the employees of the church, because it will be tantamount to religious gatherings, but the minister says there in paragraph 73 on page 00122, I deny that the terms is clear. A gathering held between religious leaders and their employees focusing on work-related issues will not be a faith-based gathering. On the other hand, my lord, a gathering attended by members of a congregation for religious purposes would be a faith-based gathering, my lord. My lord, I mean, then the minister, my lord, paragraph 74, 009-23 deals with the aspect of the police, my lord. Much has been made that, I mean, people who, I mean, flout the regulations will be subjected to arrest and will be criminalized in that discipline offense. The minister says at 74, the SAP has an obligation to enforce compliance with the regulations and the laws of the land. However, how they choose to do so does not reflect on whether or not the regulations are constitutional or not, my lord. That cannot be so, my lord.
No, Mr. Boda conceded that yesterday.
Yes, but it seems, I mean, yes.
You
Yes, my lord.
conceded that that's got nothing to do with the regulations. The police.
It seems that Mr. Boda, I would to the contrary, my lord.
No, Mr. Boda said he can't take it any further. He accepts that the police may be misapplying, misinterpreting the regulations and some of the things they may have done, but that you can't blame that on the regulations. That is still his position as far as I know. But he'll speak in reply.
Yes, my lord. My lord, I mean, I move on to paragraph 80 on 00924. The regulations do not require believers to choose between God or man. Even though the faith-based gatherings are prohibited, believers can continue to practice their faith and religions. The temporary restriction on gatherings serves a compelling state interest, my lord. Then, my lord, I mean, paragraph 81 deal with the fact that the making of the executive nature, which is something which, my lord, I will deal with in due course, my lord, when I did it. And then, my lord, next page 00925 deals with risk-adjusted strategy, my lord. It says it does not discriminate against churches. Instead, it allows government to employ nuanced responses to the pandemic through use of different alert levels. In other ways, my lord, it doesn't mean that when the government imposes, I mean, this adjusted, I mean, alert levels, the same are directed only to the church. As if, my lord, it's only the church which is being targeted and singled out in respect thereof, my lord. I mean, it does deal, I mean, it's a nuanced response to the pandemic through the use of different alert levels, because they don't only impact on church gatherings, my lord, they also impact on other gatherings. And then, my lord, this should be read in conjunction with paragraph 90 that says the risk-adjusted system merely provides for different alert levels. It therefore does not mention any specific sector. My lord. Then it says the applicant is mistaken in his conduct. The risk-adjusted strategy does not allow for collective religious activity or observances, because under the current alert levels 2 and 1, the religious sector can operate and the congregation is allowed to meet, subject to certain restrictions, my lord. Then, my lord, you deal with the 29 April, that the risk-adjusted strategy was introduced on 29 April when the country was placed on alert level 4, my lord. Then, my lord, I mean,
isn't that a key part of your case in paragraph 81.1?
81, my lord.
81.1.
Yes, it is, my lord.
Isn't that really captures the heart of your case?
But it does. I mean, but it's also said, I can I mean, deal with it now, but it's also set out in our heads, my lord.
Yes.
If maybe for the record, I can read it, my lord, to say.
No, it's fine. I've read it. Thanks.
You have read it, my lord?
Yes.
Okay, my lord. maybe for the record, can I put it on record, man?
No,
But if you have read it, my lord,
I've read it. Thank you, Mr. But that's the key part of your case.
it is, my lord. I mean,
sum up your case in one paragraph.
yes. It's in, it flows into paragraph 82, my lord,
Yes.
where it says, my lord.
Now, this question, has it not been dealt with in 82? Has it not been dealt with already in the Esau judgment? And in the new Cliques judgment, which talks of, well, if it's legislative action, it can also still be administrative. And this being delegated legislation, it would still be administrative. And if you look at the Esau judgment, it seems to have now put paid to the argument that this is executive action not subject to the PAJA test set out, the test set out in PAJA as regards rationality and everything else. Has that issue not been put to rest by those decisions?
My lord, with respect, my lord, we submit to the contrary, my lord.
Right.
We submit that the Esau judgment was incorrectly, I mean,
But it doesn't matter if it
on this point.
bound, but I'm bound by it.
We will in due course, my lord, address the court on this aspect. It is set out in our heads, my lord.
Yes.
If the lordship can look at our heads at the paragraphs, my lord, it's from paragraph 85, my lord, we deal with this issue, my lord.
Paragraph?
Paragraph 85 in our heads, page 83 too, my lord. We deal with this issue up and until paragraph. It's a lengthy argument, my lord. It goes up to paragraph page 848, my lord. Yes. But I mean, my lord, for the point which we have made, as we have said, if just for the record, I may read paragraph 81 so that when I come through it on the heads, I don't have to read it again, my lord. It says the courts, the real executive nature and therefore amounts to executive action in that the courts have recognized that the more intense scrutiny permitted under PAJA is not appropriate in circumstances where the functionary's decision-making power involves sensitive subject matter on other policy matters for which the court should show the executive a greater level of deference. This then is such a matter. South Africa faces a pandemic which risks human life and places our healthcare system under severe constraint. The government is ultimately walking a tightrope, and it is seeking to protect life and the health system, all the while attempting to keep the lives of citizens as normal as possible. The science is not clear. There's also no correct answer on how best to balance the need to reduce the spread of the virus and promoting the overall well-being of people. These involve tough choices, and it is inevitable that some policy objectives must be prioritized over the objectives of others. Simply put, these policy-centric decisions are not suitable for review under PAJA because it would unduly constrain the ability of government to implement measures to contain the spread of COVID-19. This means that the standard of review is therefore the lower standard of rationality. The test for rationality is objective. A decision passes the rationality threshold if the purpose sought to be achieved by the exercise of public power is within the authority of the functionary and viewed objectively, the decision is taken is rationally related to the purpose which the power is given. The rationality inquiry does not evaluate the policy of government, and it is irrelevant that the objective could have been achieved in an alternative way. The court is only concerned with whether the means used can achieve the objective sought. And as such, the relation past constitutional master. But if I may just, finish this, I'm gonna, after I've done this, my Lord, I'm gonna move on to this aspect, my Lord, in due course. Yes, my Lord. My lord, I think I have a point, my lord. I would like to move on to paragraphs. Well, I think the point is made with regard to paragraphs 104, my lord, that the activities of faith-based gatherings are synonymous with members being in close proximity to each other and includes activities involving, as you say, clapping hands, hugging, spreading droplets when singing and preaching, as well as the sharing of communion. My lord, I will, in due course, my lord, demonstrate to the court that, I mean, the respondents.
Okay, can I ask you this question while you're still on it? Mr. Boda's affidavit, client's affidavit, tries to say, no, but we don't do any of those things. If he is correct, does that mean you must have different regulations for one religious group and different regulations for another religious group?
My lord, that cannot be counted, my lord. My lord, if one has, my lord, regard to the affidavit of Professor Karim, right, which has been filed as an expert, I mean, witness, I mean, on behalf of the respondents. He, my lord, deals with the transmissibility of this virus, my lord. And in it says, my lord, it is the virus is transmitted through aerosols, as it says, droplets, my lord, which are airborne and stays in the air for quite a period of time. So he also does say, my lord, as to why this also, I mean, affects, I mean, the prayers which are being conducted in a masjid, my lord. I will, in due course, my lord, refer the court to that in this regard, my lord, as to what, I mean, the evidence of Professor Karim is in regard to this virus, my lord. My lord, I want to move on. I want to deal with the issue of the casinos, my lord, which appears at 117, page 00931, where the point is made that casinos are an organized industry under the Casino Association of South Africa, which is highly regulated, security controlled. A presentation was made by CASA to the Minister of Tourism regarding compliance with COVID-19 protocols. Through CASA, all casino operators have committed to defined hygiene, health, sanitization, social distancing, and the provision of personal protective equipment. Casinos have committed, 118, to training employees on compliance with COVID-19 protocol. It ensures that there is compliance with the 1.5 meter spacing, social distancing between workstations for office employees who need to be at casinos, significantly less public social distancing.
Why can this not be done with this religious? That's what their argument is. Why can this not be done with them, with the applicants? All of these commitments, what they're asking for is, well, give us the same benefits, give us the same rights.
Yes, my lord, but my lord, I mean, the point is, my lord, the casinos are organized under this association, my lord.
Groupings.
But my lord, how many churches are there in this country, my lord?
I'm thinking about that one. I don't know how to answer that question.
Yes, I think that's the difficulty, my lord, with the churches, no, because my lord, if my lord, I may just, my lord, divert a bit, my lord. We all know, my lord, and the lordship knows that in this country, certain church activities are conducted in schools, in halls, and in people's, I mean, garages, my lord. And those are churches, my lord. Now, I mean, if ever, my lord, you have to do that, how then, my lord?
I don't know if I'm allowed to take judicial notice of that. I know in informal settlements there are many churches that takes gatherings. I know people meet on Sundays in various, in open spaces in various places. All over, you can see them with uniforms. I know that. I don't know if that's each individual churches. I don't know if that is it. And I don't know whether those gatherings are prohibited. But I can't, I mean, I don't know whether I can take that as evidence.
Yes. No, but I mean, what I'm saying, my lord, is that these casinos, I mean, are organized, my lord, and it's easier to enforce compliance. Whereas, I mean, I mean, as you say, I mean, there are informal churches, my lord, in the informal settlements. And not only that, but also in the townships and in the rural areas, my lord. So, I mean,
your client, why didn't your client say all that in the affidavit? Then it will make my task easier. But they haven't said it, so I'm not sure I can take that into account. So I'm not sure that's a notorious fact that is not disputable.
I think, my lord, the point is made in the affidavit that it is easier to regulate and enforce compliance with the casinos, but not with the churches, my lord.
I think the point is about churches is made somewhere, but not in detail.
Yes.
And again, it's churches, not, I suppose it's the same. Do we know if mosques are also conducted in homes and in, I suppose, I wonder, I don't know. Okay, Mr. Mohabe.
Yes, my lord. My lord, what I want to do now, I move on, my lord. If my lord can go same affidavit, my lord, at 011, I mean, my lord, there is a supporting affidavit by the Director General in the Department of Health, Mr. Buthelezi.
Yes.
Are you there, my lord?
Where am I?
011271.
11271. No. Can someone direct me to it?
I understand, my lord, it falls under the supplementary affidavit. My juniors will direct you, my lord.
Got it.
You got it, my lord?
Yes.
It is by the Director General of the Department of Health. It confirms this affidavit by the minister. And the point is made at paragraph 4, my lord, that the country is facing an unprecedented health crisis in the form of the COVID-19 pandemic, and it is obliged to take extreme and unprecedented measures to combat same. From the standpoint of the department, such measures are science-based and supported by epidemiological and other scientific data supplied to the Department of Health on a regular, often daily basis by various institutions, including the Ministerial Advisory Council on COVID-19. Then he goes on to deal with the affidavit of Professor Karim. As described by Professor Karim in his affidavit, the initial decision to ban social gatherings, including faith-based gatherings, was based on the recommendation of the MEC, as well as the obvious risk associated with allowing large numbers of people to gather while the infection rate is very high. And then it goes on, my lord. It says, my lord, at paragraph 6, later on, in a bid to permit more activity due to lower infection rate, it was agreed that gatherings should be permitted subject to restrictions. Paragraph 7, this restriction form an essential part of government's fight, that is a strategy, risk assessment strategy, against the pandemic, as well as its plan to change patterns of social behavior so that people become aware of the risk associated with the virus and act accordingly. My lord, I then move on, my lord, to the next supporting affidavit, 0011273, my lord. 011273, that's the next page, my lord. My lord, this is the affidavit by the Acting Director General in the Presidency and Secretary to the Cabinet. At paragraph 4, it says, my lord, the answering affidavits filed to date set out the rationale behind the impugned regulation, the scientific databases underlying this, and the regular consultation held with leaders of faith-based gathering. Obviously, my lord, it refers that is obvious with regard to the issue of the scientific basis data. It refers to the affidavit of Professor Karim, which I will deal with in due course, my lord. Then, then it goes on, my lord, to deal with the effects of the COVID-19 pandemic. It says the COVID-19 pandemic has plunged the whole country, the whole world into an unprecedented global health crisis and continues to pose a dire threat and to wreak havoc amongst people. To meaningfully address the pandemic, which continues to change rapidly, the President and Cabinet act with alacrity, meeting with greater frequency than would not be the case, with meetings and agendas dedicated to the COVID-19 pandemic, and with secretarial support focused and designed to facilitate an effective and coordinated national response to the pandemic. With secretarial support focused and designed to facilitate an effective and coordinated national response to the pandemic, Then, my lord, then it sets out, the role of the NCCC to facilitate cabinet response to the COVID-19 pandemic, and that it is a committee of government, is a committee of cabinet, and it also refused inputs from the net joints, my lord, and that in fact, with regard to dealing with this thing, with the pandemic, my lord. Then, my lord, it goes on to set out as to who chairs this meeting of the NCCC is the president. And then it is not a decision-making body, that the NCC paragraph is not a decision-making body, rather it coordinates, facilitates, and implements the government's response to COVID-19. The facilities includes Dr. Lamini Zuma, that is the minister, to consult relevant minister for purposes of Section 27 of the Demo General. Then it goes on and it deals with the statutory powers of the cabinet ministers. My lord, what is important, my lord, it's where if it says, my lord, with regard to the issues, my lord, of in paragraphs stated, paragraph 13, my lord, where it says there's no right and wrong in the unpleasant situation you find yourself in. The situation is fraught with many unforeseen and unpredictable possibilities. We can only do the best we can based on the science, objective and reliable data and statistics, coupled with the inputs from relevant ministries and departments who in turn receive inputs from the custody itself. Thus, following a carefully calibrated statutory inclusion process and based on relevant information, decisions are taken, including promulgation of regulations sought to be impugned. Then, my lord, on paragraph 14 on 011277, it sets out the consultation which the president had with faith-based institutions, my lord. And it says, the president ensured that leaders of faith-based are regularly consulted on the management of the pandemic. This is important because in order to ensure that institutions are fully aware of the gravity of the situation and the complexity involved in trying to protect lives and livelihoods. You see that, man? This consultation will comment, they sets out in paragraph 15. Consultations
I thought I
with
read this somewhere. It's the lives and livelihoods. Couldn't remember where it was, but there it is. Thanks
Yes,
for pointing it out for me.
Yes. There it sets out, my lord, that 15 the convene on 19 March 2020, 20 May 2020, 2 September 2020, 1 January 2021, and the 17 March 2021, where the applicant was in attendance, represented by Advocate Nadine Badinos. Then, my lord, this important paragraph on paragraph 16, that says, because of the large number of faith-based institutions, it must be accepted that the president cannot consult with everybody. Faith-based institutions were selected to ensure a broad representation of the people living in South Africa.
Carry on, Mr. Wahab. Mr. Mokhabe, have you lost me?
No.
Yes, my lord, I think I was also saying, asking for an indulgence just to confer with my junior, my lord.
Okay. Was I lost for any moment there, Ms. Lekete? What will?
No, Judge, we could hear you.
You could hear me. Okay, Mr. Mokhabe, do you want to take a short adjournment?
I'll appreciate that, my lord.
10-minute adjournment, okay. Thank you, Mr. Mokhabe. 10-minute adjournment.
10 minutes, my lord.
Thanks.
As a court business, my lord.
Thank you.
Bye.
Oh, sorry, with this. Is it off?
Mr. Mokgakabe.
As a court pleases, my lord. My lord, at this stage, my lord, if your lordship could recall that at the start of my address to the court, the point was made that the purpose basically of the regulations was meant obviously to save lives and livelihoods, and that the court was not certain whether that aspect or that issue has been pleaded in the papers, my lord. And I did assure the court that I will ask my juniors, my lord, to go through the papers and that we'll find reference to that aspect, my lord. As such, my lord, at this stage, I would like to refer the court to the answering affidavit filed by the minister in the very same, in the FOSA case line matters, my lord. It is at 011-212, my lord.
Yes.
My lord, if my lord goes to 213, my lord, paragraph.
Someone directing me to it.
Yeah, so we may direct you. Ms. Katanes, paragraph 3.
Yes.
Where it says, my lord, it sets out the purpose of this affidavit. This affidavit is prepared in response to the relief sought by the applicant in Part B of the notice of motion, as well as a supplemental founding affidavit filed in relation to filed. So what happens, my lord, is that apparently the affidavit I've been reading to your lordship, it was in response to Part A. Then thereafter, the parties agree that going forward, each will file a supplementary affidavit dealing with further issues raised, and that then the minister will respond. And this is obviously, my lord, that affidavit filed in response to the relief sought in Part B, as well as the supplementary affidavit filed by FOSA subsequent to the order of De Villiers AJ. Then, my lord, would like to refer you, my lord, to what is said relating, my lord, to the government's response, my lord, to the COVID-19 set out in 011-220, my lord.
Yes.
Where, my lord, in paragraph 6, the minister says, in my initial answer affidavit, I addressed the nature of the virus and its devastating effect on people. I also addressed the restrictions on economic activity and the enormous consequences which flow from such restriction. That's paragraph 7. The South African economy, like the rest of the world, has been hit hard by the pandemic. Far too many businesses have had to scale down operations, cut salaries, or retrench employees in order to remain viable. Regrettably, many have been forced to shut down. This means that many people have lost their jobs, leaving them in danger of being destitute and without food and basic sustenance. Paragraph 8, the delicate balance to be struck between ensuring that the transmission of the virus is slowed down and protecting a precarious economy is self-evidently a challenging and nuanced task. And he says it is further that the president established the NCC, which comprises members of cabinet and provides a platform to these men to consult with each other. Then, my lord, if we move on, my lord, in that regard, my lord, it sets out what the government does with regard to the NCC, my lord, as to its role. At paragraph 11, it says, my lord, at page 221, continuation of paragraph 10. Because the sensitivity of the sensitive decision pursuant to alert levels and the enormous cost of every such decision taken, it is important for cabinet members to consider proposed changes to alert levels and the implication thereof for their respective portfolios. It is only once consensus is reached that at the NCC that I then effect changes to the regulations. But then it says, the NCC has to constantly reevaluate alert level because of changing circumstances on the ground. We have experienced spikes in infection rates as well as declining rates of infection. The precise reason for spikes and dips in infection rates are not always clearly evident or predictable. The reason for this is that while we have learned much about the novel coronavirus over the past year or so, much remains unknown, and knowledge and learning about the virus is rapidly evolving. Because we are in uncharted territory, government is heavily reliant on science and experts in order to inform government policy and interventions to contain the virus and manage the pandemic. I should add that this is not a uniquely South African challenge. It is universally accepted that the virus is fast evolving and that we have to make to do with the best available evidence in order to manage the pandemic and its consequences. Then he says, in this regard, he attached a statement by the Regional Director of WHO, Dr. Klug, who acknowledged that COVID-19 is a fast evolving virus. And he says that Klug indicates that while we cannot always have the best evidence at hand on which to base our decisions, we do not have the luxury of time to wait until there is better evidence available. And in order to ensure the government has necessary expertise available, the Ministerial Advisory Committee that was established, my lord. Then, my lord, it sets out, I mean, the functions of the composition and functions of this Ministerial Advisory Committee in paragraph 15 from 1617. It says, this MAC was chaired by Professor Salim Abdul Karim, who held the position until 23 March, and Marian Jacobs, Professor Ntlanhla Mkhize, Perry Shoop, and Pusha Jordan as a service vice chair. And then it sets out as to, I mean, the three MACs have been established, that we have a MAC on COVID-19, a MAC on coronavirus, and a MAC on multisectoral, I mean, MAC on social and behavioral change, chaired by Bishop Malusi Mpumulwana, supposed to be Mpumulwana, my lord, as I understand it. He is the, I think he is the chair or the president of the SACC, my lord. And then, my lord, he then sets out that he attaches at 19 the expert affidavit of Professor Karim, I mean, when the improved regulations are promulgated. It details the transmission of COVID-19 as well as its evolution. My lord, I mean, then it says, my lord, if I have to read this thing, I'll have to read the affidavit, my lord, that it indicates that while available scientific information is critical to guiding the approach to the pandemic, there's still much uncertainty about the virus and the management thereof. But one of the key issues touched by Professor Karim is the second wave of the pandemic, which experienced from around November 2020 to February 21, and the possibility of a third wave. Then it deals with the NICD, my lord, who had published a study on COVID-19 mortality rates, my lord. And then it deals with the articles, I mean, by Professor Karim on page 224, my lord, paragraphs 22 to 24. And then, my lord, where it says, my lord, the article highlights at paragraph 2, page 225, paragraph 26. The article highlights the need to employ a combination of strategies in order to prevent the mortality in a potential third wave. The combination of strategies seek to slow the transmission of SARS-CoV-2, spread out the peak of the epidemic, which will prevent hospital capacity from being breached, where there are 0 beds available for patients. And then as to how this virus was discovered, my lord, deals with the pandemic in the Eastern Cape at pages 28 to 30, my lord, and hotspots, the next page, my lord, which is what it says, my lord, and then it says, my lord, I mean, deals with the issue of the hotspots on as to why if hotspots are being declared, my lord. He says that paragraph 38, South Africa is unique in that there is constant migration of members of the between province and from urban areas to rural areas and vice versa. Many interiors still commit from other provinces on a daily and weekly basis. For this reason, it is difficult to isolate a flare-up of efficiency to a particular geographic area, my lord. And that, in fact, I mean, then on 228, my lord, he deals with the Western Cape and then the restriction of movements, interprovincial travel, etc., my lord. Then on 229, my lord, is dealing with the strain on the healthcare system, my lord, as a result of the virus. My lord, it says out there that, I mean, from 21 September to 28 December, the current 2020, the country moved to level 1. A new variant emerged and resulted in a surge. With the resurgence of COVID-19, the hospital recorded an increase in daily admission of patients. On 28 December 2020, Business Insider reported the surge in COVID-19 cases resulted in some of South Africa's hospitals being at full capacity. On 14 January, the Mail and Guardian reported that preceding week saw the second highest number of hospital admissions since the pandemic in South Africa. The net effect of the rise in COVID-19 admission was that the health system was placed under severe pressure. Bed spaces were running out as COVID-19 infections surpassed the peak of the first wave, and more patients needed ICU and ventilators. In a sense, Minister Mkhize reported that the impact of COVID-19 on human resources in the healthcare sector has been devastating. A total of 339 state healthcare workers died in South Africa between March and November 2020. Paragraph 34. The grim reality facing our healthcare sector is one of the key factors considered by government in deciding not only applicable alert level, but also the restrictions which should be put in place to sustain such an alert level while still preventing an escalation in the transmission rate. It provides the reason. This decision is informed by advice from MEC and discussion within the NCCC. Then, my lord, he then deals, my lord, with the issue of mootness on 232. My lord, it deals with the example drawn by the applicants relating to drawing an analogy between faith-based garages and other businesses like supermarkets and gyms, my lord. It says 232 paragraph 52.1. The applicant is mistaken in drawing an analogy between faith-based gatherings and other businesses like supermarkets, gyms, and casinos. The acts of buying food, eating at a restaurant, and gambling do not constitute gatherings as envisaged in the regulations. These are clearly distinguishable forms of behavior from social and faith-based gatherings. Faith-based gatherings are social in nature and should be equated with other social gatherings, such as political gatherings, and not with business enterprises. In any event, business enterprises are subject to strict constraints as provided for in the regulations. Social gatherings and faith-based are particularly risky in that people in social settings behave differently from how they behave when they go to a supermarket or a casino. The risk is greater that people in social settings will touch others and congregate closely. Two, faith-based gatherings have unique risks, namely that people may talk loudly and or sing. This increases the risk of the virus being transmitted, irrespective of whether or not masks are being worn. The risk is greater that people may remove masks or wear them incorrectly. The central premise of the declarator is thus incorrect. But then it deals with the issue of mood and the issue that, the regulations are executive in nature. And here it says, my lord, in part 58, in any event, a ministerial advisory committee on social behavior change was established under the leadership of Bishop Mpumulana of the South African Council of Churches. This MEC on social behavior is a 41-person committee, which includes representatives of NEDLAC, my lord, and NEDLAC, the ZCC, and the Public Law Center, and Section 27. It submits recommendations in order to manage the cases of COVID-19 in the health system, intervene to control the spread of the diseases, communication strategy, the research agenda, and impact of the disease on the country's economy. It was established that social behavior can be implemented in the area represented on the committee without necessarily requiring state intervention. So, in this committee, my lord, there is, representatives of the religious sector, my lord. It says, paragraph 60 again, my lord, given the inherent challenges in making decisions as efficient as possible, it is simply not practicable for government to consult with every religious association. To the extent that it used to be included in the MEC, the applicant may, of course, apply to the Minister of Health for inclusion in the SB and the SB MEC. Then it deals, my lord, with the constitutional challenge based on anti-discrimination. My lord, the important part, my lord, which also refers to lives and livelihood, is on the next page, 235, my lord. On paragraph 62 and 63, it deals with the fact that, if I may just go through it, my lord, because it's also part of the applicant's case. The applicants complained that the restriction against faith-based gatherings was the same risk not applied to other businesses. I've already addressed the difference between faith-based gatherings and other businesses. I contend that any distinction in treatment afforded is attributable to these inherent differences and is not on a ground enumerated in section 9.2 of the 9 subsection 2 of the Constitution. This does not amount to discrimination and certainly not unfair discrimination. Then Then here's the relevant paragraph, my lord, on page 60, paragraph 65. In any event, the purpose of the regulation has always been and continues to be to keep the pandemic under control and to protect lives and livelihoods. There it is, my lord. I mean, it is then pleaded, my lord. It is in the papers, my lord. My lord, then, I mean, my lord.
But it's also in paragraph 14 of the
Yes.
affidavit, which is told to.
Yes, my lord. So it is there, my lord. It's not like maybe it's not a part of the case, my lord. It is there. My lord, at this stage, then, my lord, I think even, my lord, if I move on to finish this aspect, my lord, to say, despite the emphasis placed on protecting life, it is unrealistic for government to ban public activity for the duration of the national state of disaster. There's simply not telling how long the pandemic will last and when life will go back to how it was prior to it. When public activity are allowed to avoid the transfer of virus, it is necessary to place restraint on this public activity. These sentiments apply to faith-based guidelines. Government recognizes the importance of this guideline and the role played by research organizing society. For this reason, government has permitted faith-based guidelines when infections rates are sufficiently low, but imposed restrictions in order to avoid the rapid transmission of the virus. These restrictions are temporary in nature and will be lifted as soon as it is safe to do so. Yes. Then he says, in any event, the restriction not hinder activity of religious organizations, given that they're not prohibited from having multiple services or multiple venues in order to accommodate, their congregants, my lord. My lord, then I would like then, my lord, to move on to deal with that aspect which I have already touched on, my lord, on the issue of, as you said, my lord, the executive action, whether the making of the regulations constitutes administrative action or executive action, my lord. I mean, the argument, my lord, is set out obviously on page 832 of our heads, my lord. And I think at paragraph 85, my lord.
You're right.
Yes, ma'am.
On page 244 in paragraph, she recognizes the mistake.
But on page 244.
Yeah, it's just a minor thing.
Is it in the affidavit, my lord? What?
It's there anyway.
Which one? Yes, my lord.
Anyway, it's done. Now we can do the executive nature.
Yeah, I hear. I just want to say, my lord, the aspect of consultation with faith-based leaders is also contained in paragraph 240 of this affidavit, my lord. Paragraph page 240, paragraphs 89 to 92. We set out, the consultation which government had with the stakeholders, including religious leaders.
Yes.
If there were not, deal with this aspect. But I was wondering whether maybe I should deal with Professor Karim's affidavit on deal with the issue of executive action, my lord.
On executive action, you seem to combine executive action with polycentricity.
I mean, there are three factors, my lord, that are basically, I mean, relevant to this issue of determining whether a matter is executive action or administrative act, my lord.
Right.
As set out, my lord, in page 832, paragraph 85, to say that PAJA doesn't apply because the making of the risk under section 12 amounts to executive action and not admin. Then there are these three main factors, my lord, that divert the regulation input in the statutory realm of executive action. The first one is that the matter involves policy, my lord. And you say a power that is more closely related to the formulation of policy is likely to be executive in nature, and conversely, one closely related to APA is likely to be more administrative. That executive policy making is the power to formulate high policy or to make decisions pursuant to broad directions giving powers, my lord. Whereas administrative involve the conduct of the bureaucracy and carry out the duty, the daily function of state, which will have direct and immediate consequence for individual or group of individuals, and therefore administrative power, therefore at the generally lower level, that occur after the formation of policy and involve the implementation of legislation. That this is a boiler room of the ship where government officials are required to give motion to the captain's strategy. Then it says the promulgation of regulation would prohibit a textbook example of executive policy making. COVID-19 is a once in.
Is it once? Mr. Mukhabe?
The power to promulgate regulation in order to stem the transmission
Mr.
is more closely
I lost
related.
you for a minute. I don't know if everyone else lost you, but I did.
My lord,
I lost you for a minute.
I was reading at D.
The promulgation, right?
Yes, that which prohibits gatherings a textbook example of executive policy making, and that as COVID-19 is a once-in-a-lifetime problem, there are no legislative rules or risk factor for designing an appropriate response to rising infection and the consequent result, therefore. As the power to promote regulation in order to stem the transmission of the virus is more closely related to the formulation of policy than is to the bureaucratic implementation of the legislation. And that this conclusion is bolstered in the recent ruling of Solidarity as Minister of Tourism, where decided last year, 30 April 2020, in the Gauteng Division, Tshwane Pretoria High Court, by Kolapen J, who concluded that the decision to establish an emergency relief fund in terms of the COVID-19 regulations amounted to executive policy making and not administrative action. Then we go to the limits of the power as a second indicator, whether there are constraints imposed on the power and a degree of discretion granted to the functionary. The fact that the scope of functionary is closely circumscribed by legislation indicate that the power is administrative in nature. Conversely, if it is broad, the power is more likely, executive in nature, which is the case here, my lord, because the power of the minister to make regulation, my lord, is not circumscribed or limited, by any considerations. All that the minister obviously it's required to do, my lord, if I may deal with this point immediately, is that the minister is obliged to consult with the cabinet, with the cabinet minister, the responsible cabinet minister, on whose activity portfolio the regulation might impact, my lord. And then with cabinet, it does not, the law does not require, section 27.2, the law does not require or oblige the minister to consult with any other persons. However, the minister has gone out of a way and government has gone away, despite the law not obliging them to do so. They have engaged all the stakeholders, my lord, prior to the promulgation of the regulation in order, my lord, to source their views and opinions on the matter. And only once, they've done so, then the regulation are promulgated. That is what it is, man. It will be an onerous duty burden imposed on the ministers to expect the minister to consult with each and every church, Christian association, each and every traditional leaders' council, each and every leader of a political party, etc., my lord. In the context of the pandemic, my lord, that would be irresponsible on the part of the government to embark on this kind of extensive and prolonged, theme. Whereas, the populace, my lord, lives and livelihoods is at stake. They have conducted these consultations. They cannot be criticized, my lord, that the fact, you didn't consult with me, my lord. I want to touch, my lord, on this aspect of consultation because I want to tell you that, my lord, if there are 10, if there are 5 religious associations or Christian associations, my lord, and the president consults with 4, does that obviously mean that the process is flawed because one association is not consulted? I submit not so, my lord, because in any event, my lord, once the president consulted with those who are there, my lord, and who are known, my lord, the president cannot, be required, or the minister to go around the country to search out all these religious organizations, my lord. The fact that maybe, as it is said, my lord, that the president knows us because at some stage he consulted with us, and at another occasion he didn't consult with us, my lord. My lord, it doesn't change the case any further because, does it mean, my lord, that because a party was excluded from consultation or didn't participate in consultation, would, that party's presence have changed the situation? You know, my lord. If the other parties who are there articulate the same views and opinions as the one who's not there, it would not make any material difference, my lord, that in fact, his absence would obviously render the whole process flawed or would render the regulations unconstitutional or invalid, my lord. But anyway, as it is, the default position, my lord, is that the law doesn't require the minister or the president to consult. As it is, my lord. Well, I move on. I said in Scalabrini, this is how the court decided, the Supreme Court of Appeal, that a decision to close a refuge was not administrative action because it was policy laden and included, policy of the department and broad political framework of which it must function, and that the same procedure should apply. The suitability of high-level scrutiny, my lord, is whether it is appropriate to subject this matter to the higher level of scrutiny required under PAJA. The court has required that high level is not appropriate, say, where the sufficient decision-making powers involve sensitive subject matters, my lord, or other policy matters for which the court should show a greater level of deference, and it means refers to the case of Mutau, my lord. Yeah, a paragraph. Now the point is made that managing the pandemic is not an easy task because there are no correct answers. It involves tough choices, my lord, and it is individual. Some policy objectives must be prioritized over the objectives of others. Simply put, these policy-centric decisions are not suitable for River and Apache because it will unduly constrain the ability of government to implement measures to contain the pandemic, my lord. As such, my lord, the decision we submit is policy, is executive policy making, and need only to pass the low rationality test threshold, my lord. Now, my lord, before maybe we go there, my lord, I need maybe, before I deal with rationality, I need to deal with ISO, my lord. The argument is on, it is there, my lord, on 837. Or, my lord, may I just do it chronologically? If I deal with rationality, then I move on to ISO, my lord.
Yes.
Yes. Well, my lord, it's submitted at 88 that the test for rationality is objective, and the decision passes rationality review if the purpose sought to be achieved is within the authority of a functional and viewed objectively, the decision taken is rationally connected to the purpose for which the power is given. That is tried, my lord. It's tried law, and therefore a rationality review is another question. Is there a rational connection between an objective of government and a means used to achieve that objective? And that the courts have cautioned that rationality is not about whether a decision is right or wrong, about the advantage and disadvantage of the decision. In other words, the rationality inquiry, my lord, does not evaluate the policy choice of government is also irrelevant. The objective could have been achieved through means that are more suitable, more accurate, or less restrictive. And in this regard, my lord, reference is made to the case of the Pharmaceutical Manufacturer Association, my lord, in the ex parte President of the Republic of South Africa, at paragraph 90, the Democratic Alliance case, my lord, 2013, 1 SA 248, Constitutional Court at paragraph 32, and State versus Lawrence, my lord, a decision of the Constitutional Court.
Mr. Mogabe, you've cut. Mr. Mogabe, you cutting off? Is that me or you? Can everybody hear me?
Yes, Judge, we can hear you.
Oh, okay, Mr. Mogabe, you cut off there for a second.
Oh, sorry, my lord. I appreciate that the Lord, my lordship should also, alert me if ever I'm breaking off and
Yeah,
not audible.
Thank you.
Yes, but we submit that, my lord. A finding of rationality is therefore rarely made at this on these cases at paragraph 90, my lord. The law threshold for serves an important principle of procedural systems. It ensures that the courts exercise restraint and do not stray into executive policy. And one of the reasons for this is that courts do not have the skills to prescribe economic policy and rearrange budgets. That constitutional function assigned to the elected branches of government. And in this regard, my lord, we also refer to the pharmaceutical manufacturer's case, Subramuni case, my lord, at paragraph 29. This is set out at footnote 72 of our case, my lord. We submit that in this case, the court should show caution before encroaching upon the terrain of the national executive. Obviously, my lord, in deference and respect to the hallowed principle of separation of powers. They cannot dispute that there is no rule book on how to manage the pandemic. Government has to find a way to balance the notion of the protection of people's lives with respect to other constitutional rights. And as a matter of executive policy, the minister has opted to balance these competing policy-laden decisions and polycentric priority by means of a temporary prohibition on religious gatherings that only lasts for as long as the infection rates are unacceptably high. As such, the court should be disinclined to frustrate the executive policy choices in this time of ravaging national disaster, my lord. And then, my lord, I deal with ISAO. We submit that, my lord, it concerns the challenge to the concern of certain COVID-19 related regulations, I think made under level 4, my lord. The challenge was dismissed, save for the declaration that regulation 16.2, that's the whole issue, my lord. If I may put matters into perspective, my lord, in this matter, as I understand the situation, my lord, the applicants challenged the constitutionality of the COVID-19 regulation made under level 4 in the Western Cape High Court. And the challenge was dismissed, save for the court, review and setting aside regulations relating to the taking of exercise, which was limited to 3 times, to 3 means, namely walking, running, and cycling, my lord, and also to certain times, and as also restricting you to do so not within 5 kilometers from a person's residence, as well as those regulations prohibiting the sale of hot cooked food. Those were the regulations, my lord, which were, set aside. The rest of the attack on the regulations was dismissed, my lord. The applicants then applied to the...
Is ISAO being taken on appeal to the CC, do you know?
My lord, I cannot say with certainty as to what has happened there, my lord. But
your client seems to say here that ISAO ISAO made a decision on an issue that was not properly ventilated before.
Yes, my lord.
97. Now that's a serious statement, but does that mean does it give indication that your client's taking it forward?
My lord, well,
in other words, I have to just accept that it was ventilated. I'll accept what the court says.
Yes. No, my lord, if I may draw your lordship's attention to the case, my lord, then to demonstrate as to why maybe this statement is made. I'll draw your lordship's attention, my lord, to paragraph. It is in paragraph 84 of the judgment, my lord.
84 of the judgment.
84 of the judgment, my lord.
84 of the judgment.
Yes, my lord.
Yes.
It says, my lord, although the respondents asserted that regulation making was not administrative action, they put forward no argument why this was so. They never took issue with the finding to the contrary in this court in situ of Tshwane or with the reasoning in new clicks set out above, upon which it was based. I am aware of judgments, including in this court, in which misgivings have been expressed on the issue. This case is not, however, the correct case to explore whether those misgivings have any merit. We, of course, are bound by the finding in situ of Tshwane unless we are convinced that it is clearly wrong. No attempt was made by the respondents to convince us of that. So, I mean, you see that, my lord?
Yes.
Now, my lord, on that basis, the court, my lord, I mean, without interrogating or investigating the issue or providing any reasons or motivations as to what, I mean, it thinks that, in fact, my lord, the regulations constitute administrative action, accepted at face value, my lord, just because the respondent did not, I mean, take issue with the finding to the contrary in this court in situ of Tshwane of the reason in no tracks. Therefore, I mean, the court is of the view that, in fact, I mean, it is bound, my lord. Whereas, my lord, it is submitted, my lord, that when an analysis is undertaken of the decisions in new clicks and in situ of Tshwane, my lord, it was clear that no final pronouncement was made as to whether, in fact, regulation making constitutes administrative action or executive action. The court accepted without, I mean, analyzing these two decisions, whether, in fact, I mean, that is correct or not. If I may also point out, my lord, just there, in situ of Tshwane, my lord, the same conclusion is reached without an analysis or traversing the pronouncements of the court in these two decisions, especially in your clicks, my lord. My lord, I would like to refer you, my lord, to situ of Tshwane, where, in fact, it was just a blanket statement to the effect that, I mean, the making of regulations constitutes administrative action without any motivation or providing any reasons, my lord. If the court will bear with me, my lord, I just want to get the cases, my lord. My lord, in Cable City, my lord, is a decision which was decided by Justice Maya, my lord. And
which one is
no reference is made in Cable City, my lord, as to any of these decisions being interrogated, my lord. It's just a statement. I will find it, my lord, and then I'll refer the court to it. But I think, my lord, if you have a look at our heads of argument, my lord, we have obviously dealt with that, my lord, and with that the reference, my lord, in that regard, my lord. If the lordship will bear with me, my lord, I just when I look at this case, my lord, in Cable City, my lord,
if your client is of the view, that new click had not finally determined this question, and I can understand probably why they take this view, because new clicks is such a lengthy judgment, and there's so many different versions and by each of the various justices, and the approaches are so diverse at some point, then shouldn't your client just take this issue to the Constitutional Court to decide, when is regulation making administrative and when not, if at all it is. So if at all regulation making can be administrative, then the next question will be, well, when would it be? Shouldn't your client just take that there?
My lord, I think that is, my lord, the natural course, I mean, to take to take this aspect.
You're saying that all the SCA has done is simply said that this decision is taken already in those two judgments and they're bound by it. And you're saying they haven't. That court has not taken that decision.
The SCA, my lord.
No, the CC.
Yeah, it's not yet.
See, what the SCA says is that the court has taken the decision in Nuclex and in
Nuclex, my lord.
In City of Tshwane.
Cable City matter, my lord.
Yeah. And you're saying they haven't, and the issue is not as clear cut. But more importantly, you say the SCA, to the extent that we bound by it, should have heard the matter as well and ventilated, which it didn't. I don't like to get involved in that kind of. I will not ever say I'm not following the SCA because a litigant says before me that the SCA did not ventilate the issue properly. That's not for me to determine. Then, if they felt that's the case, they must go to a higher court and take that issue up there. As far as I'm concerned, I'm bound by the SCA. The SCA says this is it, then I'm bound by it.
Well, my lord.
Am I not?
My lord, can I make the following submissions, my lord? My lord?
Yes.
In terms of the principle of stare decisis, my lord, that is, remember the book of Ellison Khan, my lord?
Yes.
Yes. Is that, I mean, a court, it is permissible for a court not to follow, to depart from a decision if the decision has been wrongly decided.
Well, if I must be fully convinced. He says it here. He says, we are of course bound by the founding of City of Tshwane unless we are convinced that it's clearly wrong. No attempt was made by the respondents to convince us of that. Now he's saying the issue was, I'm reading it, the issue was there, but you didn't want to address it. Your client didn't want to address it. I'm not saying you personally, sorry.
My lord, but my lord, the very same court also held that, in fact, I mean, it is not clear, I mean, that regulation making is an administrative action. In the Mostert decision, my lord, I think Bruce van Amstel, AJA, came to that conclusion, my lord. I think I may refer the court to the case of Mostert, my lord. Yes. So he also says so, Mr. Justice Plaskett, my lord, that although is aware of the judgment which Ms. Given expressed on this issue. But then he says this case is not the correct case to explore whether those misgivings have any merit at all. So he's aware that there are conflicting decisions by the same court on this aspect. But he's of the view, my lord, that in fact it is not the place to do so. Yes, my lord. So then, my lord, he himself has conceded that, I mean, it is not clear cut as to what basically the position is in this regard.
Yeah, the point is in Nuclex, which I should know about. Jespersen's dealt with the issue. I can't remember if the other justices dealt with the issue. Because Nuclex is such a multivarious, multifaceted case.
Even may I assist the court, my lord, the other judge, my lord, was Noble, decided that in fact it's not necessary. Justice Noble decided that not necessary to determine the issue, but he also put a gloss on this aspect, my lord. Yes.
Okay.
So in that regard, my lord, in that regard, my lord, and in view of this conflicting decision, my lord, especially of the same court, my lord, of the same court. Therefore, it means that, my lord, that in fact, I mean, the position is not clear-cut.
Why do you say the same code is different? If you look at paragraph 83, look at paragraph 83 of the Esau judgment. That court has in more than one occasion now have said that rulemaking fell within the ambit of administrative action. Now, you may think that court is wrong. I'm not going to say anything about it, but it's not for me to disagree with them. I mean, unless it's fully ventilated by me properly. And I don't think I should be the court that hears that. It should be taken to the next level, the level after the SCA. And then he goes on in 84, he says, you know, your client disagrees that it is administrative action, but then your client didn't put up any argument. Your client now says, but hold on, we were not allowed, the issue wasn't properly ventilated. I don't know that. And that's not for me to do it. It's for you to take that up further at the next stage if you want to. If you don't, then I'm bound by this.
My Lord,
Am I
if
not?
I also refer the court to the case of Mostert, my Lord. It's an SCA decision, my Lord. And it decided in 2017 after the Cable City case of the SCA. My Lord, quickly, my Lord, at paragraph 8 of the judgment, it's a unanimous judgment, my Lord, of Mr. Justice Plus van Amstel. At paragraph 8, my Lord,
yes,
this is what Justice Plus van Amstel says. A word of caution may not be out of place. New clicks, that's the one, my Lord, of Charles Carson CJ, on which Plaskett JA relied in coming to this conclusion. New clicks is no authority for the proposition that the making of regulations by a minister in general is administrative action for purposes of perjury. It seems with respect that the statements in some of the other judgments in that case to the effect that this is what Charles Carson CJ held were based on a misinterpretation of what he said. The learned Chief Justice said what is or is not administrative action for purposes of perjury is determined by the definition in section 1. He analyzed the regulation questions in the light of the definition, concluded
the definition I remember is whether it is a decision or not.
Yes.
Yes, yeah. Carry on with the quote.
That he analyzed in the light of the definition, concluded that the legislative administrative action has not been excluded from the definition of administrative action, and said it follows that the making of regulations in the present case by the minister on the recommendation of the present committee was a decision of an administrative nature. My Lord, if I recall well, you might have been involved in this case during your days at the bar.
No, I did New Clicks. New Clicks was my case, as was all the other medicine cases, affordable medicines, all of them.
So you know New Clicks, my Lord.
Well, I did the heads. I was the I did the heads of New Clicks.
Yes, my Lord.
I was one of 3 people who did the heads.
And you contended that this regulation making is not administrative, my Lord.
So one of the cases where we used to work sometimes throughout the night and then go to bed for a short while and come back.
Yes. Yes, well, so it is not, my Lord, I mean, something new or out of the blue, my Lord. Your Lord is well versed with the reasoning of Charles Carson CJ on this point, my Lord. Anyway, my Lord, if I then move my paragraph 9, in a separate judgment, express view that perjury applied to the specific medical conferred by section 22G of the Medicines and Registered Substances Act He emphasized that he refrained from deciding whether PAJA is applicable to regulation making in general. Two of the judges in the matter expressed that agreement with this approach, while Sachs J held that PAJA was not applicable, save in the specific respect of fees in the precise amount chargeable as a dispensing fee. Musaneke J held that it was unnecessary to decide whether PAJA applied to ministerial regulation making, and 4 judges concurred in his judgment. You see, madam? Therefore, he says, paragraph 10, in dealing with the application of PAJA to regulation making, Charles Carson, CJ, was therefore not speaking for the majority of the court, and as I've tried to show in any event, confined himself in this regard to the specific regulations that the court were dealing with. It seems with respect that in City of Tshwane, my lord, versus Cable City, also a 2010 3 SA 589 decision of the SCA, the position was also stated too widely in paragraph 10. My lord, this is the catchword, my lord. This is the punchline, my lord. And I'm going to read it very slowly for the benefit of the other parties, my lord. This is what it says.
For my benefit, I'm slow.
Well, my lord, Lord is well versed with these issues, my lord. We've been doing that since 2006 and 2007, my lord, you know.
So 2001 we did.
2001, my lord. You see, you have been dealing with these issues, my lord. So it's not like a new head to you, my lord. My lord, this is the punchline. Reading for the benefit of the court and the other parties. On paragraph 10 of the judgment in Moster's case, my lord. The final word on regulation making and the applicability of PAJA to it may therefore not have been spoken. And as this matter shows, not all the provisions of PAJA and paragraph section 7 are tailored for the review of a regulation. So the final word has not been spoken. And this is SCA too. And my lord, incidentally or coincidentally, in ISO, plus JA never alluded to this case.
Was it not brought to his attention? Was Mr. not brought to his attention?
I'm not sure what he says, my lord. He is aware. He's aware of this disease because he says, I am aware of judgments, including in this court, in which misgivings have been expressed on the issue. However, this case is not correct to explore whether those misgivings have any merit.
Where does he say that?
Paragraph 84, my lord.
I am aware of judgments, including in this court, in which misgivings have on is, however, the correct case to explore these misgivings any merit. We are, however, bound by City of Tshwane, and City of Tshwane is also an SCA matter.
Yes, my lord.
So he followed City of Tshwane, but not Mostert.
My lord, may I then read City of Tshwane, my lord, on this point? City of Tshwane pronouncement on this point, my lord, is contained in paragraph 10 of the judgment of Madam Justice Maya, my lord. It reads thus, my lord. The city of Tshwane municipality is a 2010. It was decided, my lord, on the 10th of September 2009, but obviously it was reported in the 2010 law reports, as alluded to in the judgment of Moster, my lord. At paragraph 10, this is how her ladyship deals with the matter. It says, I agree with the appellant's contention. I deal first with the issue of non-joinder. It is potentially crucial to the fate of this appeal. I agree with the appellant's contention that the making of regulations by a minister constitutes administrative action within the meaning of Promotion of Administrative Justice Act, which must comply with the requirements of this act in accordance with the doctrine of legality. So a determination of whether public policy has been exercised is indeed a constitutional matter, and a finding that the minister acted is effect a finding that he or she acted in a manner that is consistent with the Constitution, and that his or her conduct is invalid. But likewise, she also refers to, but she doesn't refer to new clicks here, my lord. But she does refer to new clicks in respect of what she said earlier on.
Mm.
And in respect of this matter, my lord, she refers to the pharmaceutical manufacturer in the ex parte prison of the Republic. My lord, this is the same matter that you also may be involved in, my lord. So, my lord, then the question basically is, my lord, the city of Tshwane, my lord, erroneously, if I may submit so, I mean, relied on Nuclex on the basis that Nuclex is authority for the proposition that regulation making constitutes an administrative act. And likewise, Mr. Justice Plaskett followed suit, my lord, and did the same, my lord. And that's why he says he's bound by the city of Tshwane, which was erroneously decided. And in fact, worst of all, Mr. Justice Plaskett never referred to Mosted, which I mean decided to the contrary.
Right. I'm with you, Mr. Mukhabe.
So, my lord, then I mean the submission then it's made, my lord, that I mean there is no finality on the aspect as to whether, in fact, I mean, regulation making constitutes, I mean, administrative action within PAJA in terms of PAJA. My lord, if I may just, I wanna complete this aspect. There is a case which has been, another case which has been relied on by the applicants, my lord. I'm not sure whether it's Mr. Bouda or Ms. Engelbrecht or Mr. Bouda. I think it must be between Mr. Bouda and Ms. Engelbrecht. It's the case of Afrifora, my lord.
Yes.
It's also a Supreme Court of Appeal decision. It was decided, my lord, against the Minister of Tourism. Decided, my lord, as I understand, in September this year, my lord, 22 of September 2021, which involved a challenge to the regulations or directions made by the Minister of Tourism relating to certain, I mean, relief funds, my lord. In this decision, my lord, likewise by Mr. Justice Plaskett, my lord. And then, my lord, I mean, the era continues. Mr. Justice Plaskett, in dealing with the issue of this, on this aspect, my lord, says at paragraph 33, my lord, under the subheading pathway to review. In ISO, this court held that the making of regulation by the Minister of Cooperative Governance and Traditional Affairs in terms of Section 27 of the DMOS Administrative Acts as defined in PAJA. In this case, it seems to me, similar, just he endorses his own judgment. Obviously, my lord, there was no way that he could have deviated therefrom. In this case, it seems to me the same result should follow in respect of an exercise of power that was empowered by those regulations. It strikes me as incongruous and in order to hold that despite the Minister of Corporate Governance and Traditional Affairs acting administratively when she made the regulations to authorize ministers to make directions, the Minister of Tourism acted executively and not administratively when exercised the power that had been delegated to her. So what he did was just to endorse it, my lord, likewise. If maybe, my lord, if maybe, I think what had happened here, even Mr. Justice Plaskett had a second bite at the cherry. If as he was of the view that it was not correct, it was not the place in ISO to determine whether the misgivings which have been expressed not only by the ACA and other courts regarding, I mean, this aspect, then I will submit that maybe this would have been also the right place and opportunity in Afriforum to do so. But he also failed to do so, my lord. He just, I mean, gave a blanket endorsement on his earlier decision in this regard, my lord. Yes, my lord. My lord, we deal with aspects, as we say, my lord, and we make the point in page 84, paragraph E, to say, therefore, the decision in City of Tshwane relied on by Plasket JA in ISO that Nucleus is binding for the finding that regulations amount to administrative action is plainly wrong. Nucleus is not definitely authority on this point. As recognized in Mostert, indeed, the SCA and ISO seem to have leave the door open for all argument that the regulations are executive in nature. This is unsurprising given that the issue was not properly raised or argued in ISO. Plasket JA recognized in ISO the existence of judgment, including those of the CA, which Ms. Given expressed on the issue of whether all are administrative. It, however, held that ISO was not the case to explore whether those misgivings were correct or not, or had any merit. It held that, it was bound. It says that the respondents made to attempt to convince the court that this case is wrong. This is the crucial point which distinguishes ISO from the present matter. In the present matter, the respondent pertinently raised and argued that the SCA in City of China was incorrect in its finding, which is binding authority for the finding that all regulations amount to administrative action. Instead, what Nucleus and other jurisprudence requires that the court should analyze the regulations and issue to decide whether those regulations are administrative or executive in nature. A court may not blindly assume that all regulations amount to administrative action. The nature of the regulations are demonstrably executive in nature, hence PASA find no application in the present matter. The applicable review test is whether or not the regulations are rational. Then it goes on to deal, my lord, with the issue of the case in the pharmaceutical manufacturers case, where Charles Carson set out that decisions, it is a requirement of rule of law that excessive power by the executive and other should be arbitrary, should not be arbitrary. Decisions must be rationally related to the purpose which the power is given. Otherwise, they are in effect arbitrary and inconsistent with this requirement. In order to pass crucial screw, the excessive power by the executive and other must at least comply with this. They does not fall short of the standard demanded by the Constitution.
Mr. Mogabe?
Now, my lord, the point we are making, my lord, is that maybe this may be the relevant case for the court, my lord.
There's something I want to ask you. It sounds very interesting, and I'm very happy to delve into this issue. But here's the problem. Not a problem. Here's an issue I want to just raise with you. Assuming for a minute, because this has been your major case right up front, assume for a minute you succeed on mootness. Would it be appropriate for this court for me to go on and voice any opinions on this issue?
My lord, as I had alluded to the court and made my submission.
Maybe you should drop your mootness point.
That no, I did say, my lord. You remember, my lord, I said I did submit that, my lord. If the mootness point, my lord, holds sway,
and there's
no need for the court.
You use the Latin term.
Caris question.
Yeah, caris question. Yeah.
Yes, the matter is caris question. Then there will be no need for the court to deal with any other issues raised in the matter. So to answer the lordship question, if the lordship is asked with regard to mootness, then the court will not be required to deal with this aspect in the judgment, as the Concord did in Normandy, my lord.
Yes. And you would press me to still find mootness?
Of course, my lord. Of course, my lord. We will not waive you abandoning or, dropping that point, a defense, my lord. We have argued stoically, we have argued stoically, we have argued vigorously. That's why we started with it, my lord.
Right.
Yes.
Okay, carry on, Mr. Mogabe.
Then
you seem to be coming to the end of your discussions.
Well, it seems I will be, my lord. I think, it's a question of now dealing with the rationality, my lord.
And then you have to deal with, if you're right there, but if you're wrong on executive action and whatever, then you'll also have to deal with the limitation argument, wouldn't you?
Yes, my lord.
All right, I see you've covered it in the very document about nature of the right, etc.
Yes, my lord. It is covered, my lord. The issue of the justification and the nature of the right, my lord. It is covered in the heads, as well as the issue of the rationality, my lord. It's covered in the heads in that regard, my lord. Then, if I have then to traverse it, my lord, with the matter, my lord, or whether maybe my lordship would be not necessary for me to do so. I mean, I am happy, my lord, to proceed and address the court on this rationality issue, my lord.
Yeah, let's go on with the rationality.
Okay, my lord. I mean, my lord, I mean, in a nutshell, my lord, I think, I mean, as I said, my lord, I mean, the test is that, as you say, my lord, decision must be rationally related to the paper which the power is given, otherwise they are in fact arbitrary and inconsequential requirement. In order to pass constitutional scrutiny, the exercise of public power by the executive and other functions must at least comply with this requirement if it does not fall short of the standards demanded by the Constitution for such action. I mean, the purpose which the power is given is reflected in Section 27, subsection 2, which empowers the minister, after consulting with the responsible cabinet minister, to make regulation or issue directions, my lord, or authorize the issue of directions related to an extensive and broad range of activities, my lord, which are also set out there, my lord. The minister, in terms of Section 27F, my lord, has the power to regulate the movement of people from disaster-stricken areas. Section 27, subsection 2, my lord, which is the one in issue here at play, permits the minister to make regulation, permitting the taking of other steps that may be necessary to prevent an escalation of the disaster or to alleviate, contain, or minimize the effects of the disaster. But these powers, my lord, are only limited for 5 purposes, which is to assist and protect the public, providing relief to the public, protecting property, preventing or commanding disruption, or dealing with the destruction and other effects of the disaster, my lord. We submit, my lord, that in the current pandemic, my lord, in certain circumstances, faith-based care have to be restricted in order to avoid them turning into super spreader events and propelling the transmission of the virus. My lord, when we deal with that, the ISO decision, my lord, and we say the ACA as such, not quite procedural fair, but ACA said, my lord, with regard to applying, I mean, this test of rationality to the regulations, which, I mean, from the subject matter of the challenge in SAU, my lord, that all regulations, but which it was, the SCA as such is not quite procedural fair following the findings in Masitla and in Tau. We submit that, my lord, there was a limited requirement of procedural rationality as held in Albert, and that the SCA found that such requirement must be restrictively applied, the rationality test, and then it held that the DMA does not prescribe procedure for the making of regulation in terms of Section 27. That's left to the COGTA minister, who, whatever procedure she chooses, is under a duty to act fairly. The absence of procedure in the DMA is not surprising given the nature of disaster. In some cases, such as flood or an earthquake, for instance, extremely urgent action may be required to manage the disaster, while in other cases, a long drought, for instance, more time for reflecting, planning, and may be available for decision makers. The definition of a disaster recognizes a sliding scale in the nature of disasters, ranging from the sudden to the progressive. Within this context, my lord, the COGTA minister was required to assess the urgency of the matter and calibrate the procedure adopted by it, including the time to allow for the making of representation to the degree of urgency. Then say in the weighing up, it deals with the weighing up process, my lord. The need to relieve population of some of the more draconian economic and social restrictions was an important factor. As the lockdown regulation impacted on the rights of people, their planned amelioration brought with it a measure of urgency for the limiting of the time available for members of public to make representation. As soon as the regulation no longer served legitimate purpose, they are to be repealed or amended as quickly as possible. It is also important to bear in mind that the level of 4 regulation in their final form will not necessarily to be final word on level 4 restriction. It has always been made clear by the COGTA that rulemaking in terms of the DMA was flexible, particularly in its response to the pandemic. The government was feeling its way in hitherto uncharted territory. There may no blueprint for how to respond to so unique and unexpected a disaster. If a measure was not in retrospect appropriate for the purpose of the DMA, it could at should not be repealed or amended. Then he says, when the nature of the process is viewed holistically in the context of the DMA, the self-prevailing respect of the lockdown and that have been enforced and the intention mirror some of the economic and social harness of the lockdown regulation. I am of the view that the 2-day period was reasonable, granted to the members of the public. Then we submit that for present purposes, it is significant that government has held extensive consultation with a broad spectrum of regional in order to inform them of the risk posed by the virus and the need for restrictions. The earliest consultation was held in March 2020. There were other extensive and ongoing consultations with regional leaders throughout the pandemic. The most recent being in 17 March, where the applicant was afforded a approach to make representations which were considered. despite the applicant being a legal advocacy group and not a faith-based organization. The religious consulted despite the DMA not requiring consult, and to the extent that the applicant relies on PAJA doesn't apply. Then you say, my lord, in fetus matter, my lord, that is the matter that was decided by the full bench in the North Gauteng High Court. The question was whether the ban on tobacco was rational as a means to combat the spread of COVID-19. The court held that for rationality, the means chosen did not have to be the best suited to achieve the intended purposes. Hence, the minister's choice to ban smoking was not susceptible to review on the ground of irrationality, unless there was no rational link between the means and the purpose for which the minister's powers was exercised, was conferred. The only thing that the court needed to determine was whether a rational connection existed between the legitimate government purpose to contain the spread of COVID-19 and the means chosen, namely the ban on the sale of tobacco growers. The court held further that the link between smoking and the spread of the virus was not completely established by the material before the minister. Her disease was properly considered and rational law intended to assist the state in protecting lives and curbing the spread of the virus. Under the rationality review, the question was not whether better or less restrictions could have been adopted, but whether the means that were adopted forced a rational connection with the intended end. The court also held that the argument that the minister did not allow proper public consent was ill-conceived. All that required was that the process leading up to the program of the law was rationally related to achieving the purpose sought to be achieved, as has been demonstrated.
Okay, Mr. Mogabe, you can then move on. I know all that. Absolutely. Can we move on to the challenge based on freedom of religion?
The nature of the Section 36 analysis, my lord.
Yeah, the Section 36 analysis.
Yes, my
and
lord.
then after that, I think you're almost done with your submissions, if I can understand.
I think so, my lord. I think so.
I think you'll be done before lunch is over.
Well, my lord, I will be done. I mean, there are other, maybe, if your lordship says be done, I'll just maybe have to.
I tell you what we'll do. Finish the limitations analysis. We can then take the lunch. You can then decide and sum up and say what more you want to say. But by the looks of it, you've quite comprehensively dealt with your client's case.
Yes. My lord, I mean, with regard to the justification, I mean, analysis and the limitation, I mean, analysis, I mean, we submit that, my lord, this involves the weighing up of competing values and ultimate and assessment based on proportionality. And that it is also stated that the purpose, effects, and importance of the infringement should be placed on one side of the scale and the nature and effect of the infringement caused by on the other side of the scale. And that is decided in Bulwana by the Concord, my lord. The case is at footnote 100. The nature of the right, my lord, which is in French, my lord, it is accepted that the right to legal freedom is an important right protected in the Bill of Rights. However, this specific right is the right to meet physically in order to worship in congregation. This is but a small component of the broader mass right to freedom. The importance and purpose of the limitation, the importance, my lord, is clear. I mean, it is undoubted, my lord. I mean, that the importance and purpose of the limitation, my lord, is clear and it cannot be countenanced. I mean, the importance, my lord, obviously, of restricting, I mean, religious gatherings, I mean, can never be on forever. So it's aimed at preventing transmission of the virus, thereby saving lives and livelihoods. It is meant to flatten the curve, my lord. It is meant to stem the tide or the transmission of the virus. It has been said even in all the cases, including ESO and all the other cases relating to the COVID-19 regulation, my lord. That is basically the primary purpose of this regulation, my lord. And then we say, my lord, in NICRO, the Constitutional Court said, in a justification analysis, facts and policies are often intertwined. There may be instances where cases concerned which lists address are subjective and not capable of proof as objective facts. A legislative choice, my lord, in fact, what it says is that the fact is not always subject to courtroom fact finding, based on reasonable inference as supported by empirical data. When policy is an issue, it may not be possible to prove that a policy directed to a policy will be effective. It does not necessarily follow from this, however, that the policy is not reasonable and justifiable. If the concerns are of sufficient importance, my lord, the risk, this is what it says, if the concerns are of sufficient importance, my lord, the risk associated with them sufficiently high, and there is sufficient connection between means and end, that may be enough to justify the action taken to address the my lord. In Mohammed, my lord, I mean, Mohammed, obviously, my lord, case, it also, I mean, it's an answer to Mr. Boda's case, my lord. I'll just submit, my lord.
He did that. I think he was in that case.
He was involved in that case, my lord. He lost. And I want to make the three submissions, my lord. This case, my lord.
He's going to lose here.
This case, my lord.
Yeah.
Shorn of all niceties, my lord. It's a replica or similar to Mahomet, my lord. At the nub of the MLA's applications complaint is that, in fact, the regulations forbid them to exercise or perform the 5 salas, my lord. And that was the nub of the case, obviously, in Mahomet. Yes. And then, I mean, Her Ladyship, Newcastle, decides to do the case, my lord. On the issue of the pain suffered by the applicants, as well as in this case, he said, my lord, I mean, the whole nation has been asked to make huge sacrifices in their lives. So it does not lie in the mouth of the applicants to complain about this kind of limited, obviously, limitation, I mean, to their right, my lord. It is there, my lord. I don't know, I believe at the point if the court wants me to read it, I will ask my lord. Read, but the fact is that in that case, my lord, the challenge to the regulations was dismissed, my lord. Yes, it was dismissed. I see that Mr. Board has tried, my lord, to salvage the situation by finding a supplementary critiquing, I mean, the decision. What I say, my lord, instead of doing so, if Mr. Board was aggrieved about the judgment, should have taken it on appeal, rather than indulge in criticizing, I mean, the judgment in the form of a supplementary, I mean, heads of argument, my lord. The judgment is binding.
We're not doing the same with Esau.
No, my lord, there's a vast difference, my lord. In Mr. Boda's case, he advances no authority to show that, in fact, I mean, the case was wrongly decided, my lord.
Right.
Yes, he just goes on and analyzes that, in fact, the court should applied the wrong approach, you know, my lord, and etc. And that this is how it should be approached, you know. Whereas in our case, my lord, it's totally different, my lord. But my lord, the question is, I mean, in the absence of any conflicting decision in Mahomet, my lord, Mahomet stands. It's binding. It's not been taken on appeal, and it stands.
Okay.
My lord, this is what we call the system, my lord. The extra from Mahomet. In other words, for it to be found that the lockdown regulations impose a reasonable and judgment limitations on citizens' rights as enshrined in the Bill of Rights, the respondent not show. So the respondent not show that they will achieve the objectives of stemming or reaction to COVID-19 pandemic. The respondents need not show that they will achieve their objectives of stemming or eradicating the COVID-19 pandemic. It is sufficient to show that the regulations are a rational measure designed to achieve that end. In the present matter, this translates into requiring the respondents to demonstrate that the impunity are a rational measure designed to achieve the objective of stemming the transmission at a time when the infection rates are alarmingly high. My lord, we say the rationale are plain to see, and we quote Hussein's case, my lord. And then, my lord, we submit that the limitation of physical gathering is justifiable in this unusual condition. It does not amount to unfair violation of rights provided in the Constitution. And we deal with the nature and extent of the limitation. We say, my lord, it is only of a temporary duration and lasts for as long as the infection rates are dangerously high, my lord. And that if this was also been shown, my lord, that what had happened, my lord, is that the general regulations were replaced for 3 weeks, my lord. In fact, it lasted for 3 weeks, my lord. The regulation lasted for 3 weeks, my lord. Only 3 weeks. They were imposed on the 11th of January, my lord. And then, I mean, they were then, I mean, replaced on the 31st of January. On the 1st of January, my lord, then, my lord, the new regulation came into operation, my lord. So as soon as the infection rates dropped, my lord, The regulations were replaced, were superseded. Yes, that's it, my lord. And that was the nation extent of the thing. But basically, my lord, it is in respect of the application and adoption of the RAS, the risk-adjusted, strategy, my lord, is that government lowers alert levels as soon as it's safe to do so. Then the relation between the limitation and its purpose, my lord, it is set out. The limitation and its purpose is clear in the manifest. The limitation is designed to eradicate the risk associated with gatherings and several when infection rates are exceptionally high. The less restrictive means, my lord, there are no less restrictions to achieve this purpose. The experts relied upon by government, Lord, advise that the temporary prohibition is necessary when infection rates are generously high. And the fact that the government employs the risk-adjusted strategy to ensure that the most stringent measures are only in place for the shortest possible duration demonstrate that it is committed to employing the least restrictive means possible, my lord. My lord, I not deal with the issue of the equitable relief. I will then, my lord, move on to deal, as the court said, my lord, I will then maybe decide, my lord, what issue to do with regard to this issue aspect of the essential services, my lord.
Okay.
The only thing I must say, my lord, is that it appears that this order may be impermissible, my lord, in the sense that we know that in terms of the Labor Relations Act, for people to be declared essential workers, services workers, my lord, they must go through a certain process, apply to the Essential Services Committee, and then a panel, as your lordship knows, and then this is all this things, my lord.
I chaired the panel for many years.
Yes, you know the process, my lord.
I was put there by Kusatu. Kusatu asked me to, at that time.
You've paid your dues, my lord.
Kusatu asked me to go and serve on their behalf. Yeah.
Yes, you know it well. But what you say, man, is that if it seems that the court cannot usurp the power or competence of the minister.
But isn't your client saying all those other items, those that were referred to me yesterday, none of those came before the Essential Service Committee. None of them were promulgated by the Essential Service Committee. So is not your client declaring essential services outside of the general Essential Service Committee's work?
Well,
is not the essential services you're referring to different from the essential services that are referred to in the Labor Relations Act? In the Labor Relations Act, if I recall, and I'm sure Mr. Boda knows this better than me, the reason for declaring a service essential services, declaring them essential, was so that it impacted on their rights to strike. And in return for their right to strike, they were given the right to compulsory arbitration.
Yes, ma'am.
And it was committees, in a sense, it was linked. In a sense, it's linked to this case, but it's a process followed differently from this case. In that case, it says if it affects the right, health and safety, the life, health and safety, and something else, I can't remember it now, then yes, Essential Service Committee may declare the service to be essential. The health, safety, life, and something else, I can't remember it.
Yes.
And so any employer, private employer or public employer, would have had the right to apply. That's why I remembered how Section 77 of the Labor Relations Act drafted would apply to that body. So you would have, for example, old age homes. If I remember the case, I gave a number of decisions. I wrote a lot of the decisions while sitting there.
Yes, ma'am.
Then the old age homes would come and argue that the employees there would be deprived of their right to strike. Remember, the right to strike is also protected in the Constitution.
Indeed, my lord.
So
Indeed.
this body could take away that right and then in return give you the right to compulsory arbitration for any dispute that arises in the workplace. Now we have a different situation here It's got nothing to do with employer-employee relationships. And it's got to do with healthcare workers who, in terms of the ESC, are already declared. All of those nurses, doctors, they've all been declared. Provision of water, all declared essential services in my time. Police services, they were already declared essential services. In the present case, it's slightly different now. Your client has gone a bit further and have declared a number of other people essential services. And here's the other difference. In their previous case, in the previous definition, or the labor relations related definition, it's restricting a right of an employee and then substituting it with something else. In your case, you're giving an essential service worker certain added benefits that are not given to the rest of society, i.e. the right to move around, i.e. the right to meet. In other words, not to be totally bound by all the regulations, the right to travel from one province to another, etc. So you are empowering them rather than restricting them. It's a slight difference between your essential service declaration and the Declaration of Essential Services in terms of the Labor Relations Act.
Well, my lord, it may at first blush appear to be so, my lord, that it is. But my lord, what I can submit is not, conceding that maybe the minister, that this process didn't go via the process envisaged in the Labor Relations Act in terms of Section 77. I would maybe submit as I'll submit so much that, my lord. Do we know the process that was followed that resulted in the minister including these people in that Annex D? Yes.
Yeah.
That the process might be obviously entail that you apply first and then your application is considered before you're included in that Annex D. It's not like an automatic thing that is done in an arbitrary, haphazard fashion. Yes.
Do you apply to the minister? No.
I say we don't know whether, in fact, my lord, you apply either to the minister or to a particular committee. There in the I'll have to check it again, my lord. But it cannot be contemplated that, my lord, people are placed there willy-nilly, my lord. Without them applying, or without them maybe being invited, my lord, etc.
You know what's interesting is in the ESC cases, the employees, the worker doesn't want to be declared essential service worker because there's a right taken away. In this case, the person's asking to be declared an essential service worker.
Yes. That's what I'm saying.
He's being conferred certain powers and certain rights denied to the rest. Yeah. So I'm not sure that analysis or analogy is going to help us, but we'll see what Mr. Boda and others say. And
I wonder whether is it the right time to take the lunch adjournment.
Yeah, and then you come back. I think you don't have much more left.
Yeah, I don't have much, my lord. Yes.
You don't have much more left.
Yes,
okay.
That might be my closing point, my lord. Just have to.
Okay. Okay, then we'll be done by today.
Yes.
Is there everyone else? Can we take the adjournment now?
Yes, thank you, my lord.
We can. How long does we want? Half an hour?
Half an hour, fine, my lord.
Is it
Half an hour.
Half an hour, fine. Okay, let's adjourn till about 25 to 2 or 20 to 2, right?
Is it 20?
25 to or 20 to 2, I don't know. Somewhere around there.
22 is fine, man. 22 quarter to is fine.
Okay. Thank you, Bo. Thank you so far. We'll just adjourn for the time being. Court is adjourned.
As the court pleases, my lord.
Mr. Compton, your video is on. Nice shot.
We got an extra break.
Yes, my lord. I won't be long, my lord.
My apologies. But you want 5 minutes?
Yeah, 5 minutes, quick, my lord. I may even be less than 5 minutes, my lord. I mean, we have exhausted, my lord, dealing with the issue of the essential services workers, my lord. The submission that I need to make, I mean, to round up this aspect, my lord, is that I think the relief that they seek is incompetent, my lord, in that, as I understand, they are notice of motion, my lord. They seek an order that they be included in the category as essential services worker under the category of caregivers and social relief of distress workers. So, my lord cannot do that, my lord. It will be impermissible for you to do that because that will be usurping the function, my lord, of the executive, my lord. Secondly, my lord, they are also asking that the failure by the minister or government to consult them prior to the whatever, I mean, the compilation of this list should be declared unconstitutional and invalid, my lord. My lord, I will submit that, my lord. I mean, the case was never made out that effect, my lord. I mean, they will be required to be consulted prior, I mean, the compilation of the list. I think it's something which, I mean, they raised only in argument or by amending, I mean, the prayers that they seek, my lord. That is with regard to this aspect, my lord. My lord, the second aspect that I want to deal with is with regard to the case of Batsa, my lord. My lord, do you remember the case of the Western Cape High Court, my lord? My lord, which
the SCA?
It has been, yes, my lord. Leave to appeal to the SCA has been granted, my lord. So therefore, it's on appeal, my lord. So, and until, therefore, it entails, the net effect, my lord, in law is that until, I mean, the SCA determines the matter, I mean, Batsa, my lord, I mean, it's sort of suspended, my lord. Cannot operate, it's not binding. I mean, yes, my lord. No, the third one, my lord, is on the issue of foreign law, my lord, which is used by the parties, my lord. Our submission is the following, my lord. One, my lord, that the court can only have regard to foreign law in instances whereby there is a death of authority on the point on which the court has to decide. We therefore submit, my lord, that as there is, my lord, plenty authority, my lord, locally on the points on which the court has to decide, there will be no need for the court to allude to foreign law unless it for a court to, for as a matter of whether if it will be useful or not. But obviously, my lord, the court will be guided in the court's judgment by, I mean, the authority.
One is always guided by the reasoning.
Yes.
I mean what's the opposite of opposite dictum? Raison d'etre.
Right. Yes.
One is always guided by their raison d'etre, and we do always have regard to them.
Yes, my lord. But what the submission, my lord, is that in view of the fact that there is, I mean, a long line of jurisprudence in locally that is relevant to the issue the court has decide, the court can only have regard to foreign law for purposes of guidance, and if it is on point.
Yes. Is it on point or in point?
On point, my lord.
On point.
But we say, I mean, it might be in point or on point, but I think it's on point. But the question is that, my lord, if that's our submissions. My lord, we have, my lord, I mean, a glut of jurisprudence in our country, flowing from the Constitutional Court up until the High Court on these issues, my lord. Secondly, my lord, we are saying, I mean, there's always a word of caution in applying foreign law, having regard to the fact that, my lord, the jurisprudence and the legal framework against which these cases are decided overseas is not the same as the jurisprudence and legal framework that is applicable locally, my lord.
Thank you.
And then, my lord, lastly, my lord, on the question of cost, my lord, we just want to say, my lord, the issue of cost was pursued in our heads of argument, which at the time were drafted by Advocate Kameshni Pillay, largely because, my lord, in their papers, I understand FOSA and Solidarity had asked for cost. Now we have come to ascertain that in their heads of argument, they are not pursuing cost. Likewise, my lord, we are not pursuing the issue of costs.
Thank you.
In any event, biowash, my lord, is applicable.
Thank you.
In the circumstances, my lord, we submit that a proper case has been made out, or a proper defense has been made out by the respondents, and the only order that the court can grant or return is to dismiss the applications, my lord.
When you say a matter is moot, the order comes out saying the application is dismissed.
Correct, my lord.
All right.
My lord,
when you come to the conclusion it's not, then you hear the whole thing, and if you agree with if you agree with the respondent, then it's the application is dismissed.
That's the order that is always, my lord, been returned, my lord.
Yeah.
I mean, in Normandie, they just said leave to appeal is dismissed, right? And then in Langeberg municipality, my lord, I think a similar order, my lord. Yes.
Thanks.
Is not an intergovernmental deal for people, yes. But my lord, I mean, lastly, my lord, just quick, my lord, if the lordship would indulge me, my lord, the question is, my lord, on this aspect of ISO, my lord, relating to administrative action vis-a-vis executive action, my lord. During the lunch adjournment, my lord, I mean, it was brought to my attention that clients would appreciate that if ever is possible, the judge in his judgment should deal with the matter, because it is important that the matter should then serve before the SCA. Sorry, before the Concord, my lord, as a for final pronouncement.
Have you taken it out to Concord?
As I understand, my lord, it's not been taken as it is now.
So they want me to give them an opportunity to go there?
Yes, my lord.
Oh, okay.
Thank you, my lord. My lord, if there's anything, which you should address me on, my lord, I am at course disposal to do so, my lord.
Thank you, Mr. Mohammed.
Thank you, my lord.
Thank you. A reply. Mr. Boda, Ms. Martin, Ms. Engelbrecht, and Mr. I forget your surname. Have you worked amongst yourself as to how you're going to do the reply, or you're just going to reply as you wish?
My lord, if I may address the arrangement as I understand it, we will reply in the same order that we addressed you initially, and I will largely stick to the topics that I addressed in the main address, and I think the same pattern will be followed by my learned colleagues, subject, of course, to pointing out peculiarities relating to our own applications if necessary.
Okay, then Ms. Martin starts.
No, Ms. Engelbrecht starts, my lord.
Oh,
Engelbrecht is correct.
Oops. My apologies.
I know I'm the youngest kid in the playfield, but not in years, but in seniority. But it is Ms. Engelbrecht who starts.
Okay.
My Lord, maybe it is because I stuck to my time so diligently that you may have forgotten that I spoke at the outset.
Yes. I think it was a good example to people of how to stick to their times. Mr. Mokhakabe was the other one who stuck to his times. He was given the whole day and he took less. Let's proceed with yours. It is right. You did mootness, you did affidavits in motion, proceedings, tests, and review, partial or legality.
Yes. Lord, Mr. Mokhakabe faces a fundamental problem in relation to his arguments on both mootness and whether PAJA applies. In both cases, he is faced with the reality that this court is bound by ESO and by the judgment in AfriForum.
But is this court not bound by the other judgment in the SCA, Mostert?
My Lord, the point is this. There is also the judgment in New Clicks, where it is true Justice Chaskelson did not write for the majority, but a number of the other judges did not differ from him, but simply concluded that the matter needed be determined for purposes of this case. So the clear guidance that comes from the Constitutional Court is that regulations ought to be treated as administrative action. There is then the judgment by his Lordship, Mr. Justice Plaskett in ESO. It is followed in the AfriForum case. And of course, my learned friend focuses very much on the fact that in both instances it is Justice Plaskett writing the judgment. But of course, in each one of those cases, it is a unanimous judgment where 4 other judges of the Supreme Court of Appeal agree with Justice Plaskett. The point is this, that the ESO judgment is in any event a judgment that is particularly concerned with regulation making in the context of COVID-19. The AfriForum case, which then confirms it, is also particularly concerned with administrative action in the context of the COVID-19 pandemic. So insofar as it is suggested to your Lordship that there are different judgments of the Supreme Court of Appeal that might offer you with a choice, then we would submit that the appropriate choice is made when one follows those judgments of the Supreme Court of Appeal, to which first the court is bound, and second, which apply particularly to regulation making in the context of COVID-19, as opposed to that which is said in Mostert, which does not concern that. Now, against that backdrop of the general introduction, that it is important to also note, as my learned friend was forced to concede, that the Minister did not take the ESO judgment on appeal. The second point is that already it is so that the AfriForum judgment, and you may take judicial notice of this, there the Minister did make application for leave to appeal. So your Lordship need not rise to the occasion of an invitation to differ from ESO in order to get an appeal on ESO through the back door, which the Minister didn't take through the front door. If there is something to be said in due course about this, the Constitutional Court, if it's in its wisdom, wants to give leave to appeal in the AfriForum case, it will address this issue. But we would submit it would not be proper for this court to rise to the occasion of the invitation offered by my learned friend.
Okay.
On the issue of mootness, there are a number of issues that arise, but it is important that I make the following points. The first one is this. A case like Langeberg simply doesn't find application. Because as my learned friend put it this morning, in Langeberg the elections came and went. Now, in the present case, the state of emergency came, but it hasn't gone. It continues to exist. The basis for the minister making regulations in relation to, amongst other things, religious gatherings still exists. And so the matter is not moot. The second point on mootness that my learned friend makes is that he says, well, we don't know what the next ban might look like, what the circumstances might be. But in support of that submission, he talks about different levels of how many people are allowed in particular meetings. Now, your lordship will appreciate and understand, in the present case, the challenge of my client is not about restrictions on numbers. It is concerned with bans, outright bans only. And so when we accept that, we must accept that a ban is a ban is a ban. It will always look the same. It will always mean that you cannot gather on the basis of faith. And so we say the idea of a factual situation that the ban looks different is no answer. The third point on mootness, which I think was first raised by your lordship, was the question of whether the vaccination rollout might have an effect. Now, that depends, as your lordship pointed out, on the question whether your lordship can take judicial notice of the vaccination rollout in circumstances where the minister filed a supplementary affidavit but did not deal with the vaccination issue. But we say, even if your lordship takes into account the fact that there is a vaccination rollout, that's no answer to the mootness question. The first point about that is, insofar as your lordship takes judicial notice of the vaccination.
Am I allowed to take judicial notice? Is it a notorious fact that vaccination rollout has taken place, and that fact cannot be disputed by anybody?
That is correct.
What cannot be taken into account is how far it's gone,
yes,
and what impact it has. That we can't take into account. But
exactly.
what we can take into account is that this has occurred. It's like taking into account that the sun is set.
Yes.
Now, surely no one can debate that the sun is set.
Yes.
But we don't know about what happened or how it's set or that we don't know all details about it. Then
yes,
we don't take that into account.
Well, precisely, my lord, because the problem is we can take your lordship can take judicial notice of the vaccination rollout, but the question is, what is the effect of that? Because once your lordship says, well, the fact of vaccination influences mootness, there must be a reason for that. And then that must be based on, for example, a conclusion that because of vaccination rollout, there won't be a great big breakout again. But that's not a conclusion that this court can reach. South Africa, that you can take judicial notice of, has a notoriously low level of vaccination take-up at the moment. We know that in a country, for example, like Germany, where there is a 65% rollout rate, right now, people in Germany are being sent to different countries because the hospitals in that country cannot cope. So the fact of a high vaccination level is not an indication that there might not be a ban once more. So we say, insofar as your lordship takes into account that there is vaccination, we say there is no consequence that attaches to the fact of the vaccination rollout for purposes of determining whether or not the matter is moot. Then the next point we address is the question of the review test. Now, as with mootness, this is a matter that is addressed in both ESO and AfriForum. And I must point out immediately that Mr. Mokhahar, sorry, now I'm slipping over my own words. My learned friend relied on the judgment of his lordship, Mr. Justice Colopin, in what he called the solidarity matter, where it had been said that the regulation making was executive and not administrative. What my learned friend appears not to have appreciated is that it is that judgment of His Lordship Mr. Justice Colopin that had been overturned in the so-called AfriForum judgment of the Supreme Court of Appeal, the one in which His Lordship Mr. Justice Plaskett confirmed the ESO finding on reviewability. And so we say that is no answer, and I've addressed your Lordship on the fact that His Lordship is bound on that review test. But again, and I've made this point, but I'll make it again, on the question of where we go next, how do we evaluate, even if it is not reviewable under PAJA, then we still remain a country under the rule of law, and that means the principle of legality applies. Now, the minister must satisfy either the test under PAJA, or she must satisfy the test, the rationality test. And in order to do so, she had to put up a record, she had to put up reasons, and she declined to do so. And we were taken this morning at some length through the affidavit in the Freedom of Religion South Africa case. I invite your Lordship to go to the answering affidavit in my client's case, which has none of the detail. In that case, essentially the only reason offered to my client was that it was more difficult to control religious gatherings than it is to control other gatherings. But be that as it may, even if we take the Freedom of Religion South Africa answering affidavit, where the minister makes a variety of statements about why she did things and how she made choices and how she controlled it. What we know is we don't have a record. We don't have confirmatory affidavits from various people who allegedly supplied statistics to the minister. We simply don't have the information underpinning all of this. And in that regard, if I may refer your Lordship to first the matter of President of the Republic of South Africa and others versus M&G Media Limited, that is 2011 2SA 1 SCA, where the Supreme Court of Appeal made the point that in the South Africa of the past, courts were regularly confronted with laws that precluded them from going behind the conclusions and the opinions formed by public officials. Mainly
which paragraph are you reading?
That is in paragraph 18 of M&G Media.
Thanks.
And the reason why that was because the statutes in question entrusted to the repository of the power the sole and exclusive function of determining whether, in its opinion, the prerequisite fact or state of affairs existed prior to the exercise of the power. That's still in paragraph 18. But what the M&G case makes clear is this is no longer the case in the South Africa post-democracy. Public officials cannot just assert conclusions in the expectation that their conclusions put an end to the matter, as it is put in paragraph 19. It is not a sufficient defense for public officials to state their conclusions without providing an evidential basis for their assertions. And if assertions seem to have been simply constructed, then they may be summarily discounted. And that is at paragraph 46 of the M&G judgment. There is also the judgment of Walele versus City of Cape Town, that is 2008, 6 SA 129 CC, where the City of Cape Town made certain assertions that were not borne out by objective facts that were provided. The city mentioned certain documents and said that those were the only documents that served before a decision maker. The Constitutional Court found that there could be, I quote, no doubt that these documents could not reasonably have satisfied the decision maker, unquote, or that if indeed the decision maker was so satisfied, his satisfaction was not based on reasonable grounds. That's at paragraph 60. And there the court observed, in the past, when reasonableness was not taken as a self-standing ground for review, the ipse dixit would have been adequate. But that is no longer the position in our law. More is now required if the decision maker's opinion is challenged on the basis that the subjective precondition did not exist. The decision maker must now show that the subjective opinion it relied on for exercising the power was exercised on reasonable grounds. That's also at paragraph 60. And we understand, Your Lordship was intimately involved in New Clicks. Your Lordship will know from there that it was not sufficient to just have a rubber stamping of a recommendation. And so I can carry on. So the point is simply this: it's not good enough for the minister, without the support of a record, without the support of information, to come and seek to justify her decisions, whether in a PAJA review or in a rationality review. And I will just revert us now to the question of the rationality. Because the important point that the minister seems to miss is, on the one hand, she makes the point that this decision is polycentric. The poly in polycentric, of course, means many. There are many considerations that have to be taken into account. Now, when she is making a rational decision, because she says that rationality is all that is required here, she wants to make a rational decision in a polycentric context. She cannot selectively decide which of the matters she must bring into account. And the one golden thread that runs through the submissions made before you is that there is an emphasis placed on, as it is put, lives and livelihoods. But if the rationality of the emphasis on lives and livelihoods is tested, it must be tested in the context of the Constitution. The Constitution that provides not only for freedom of religion in section 50, but in section 31, in addition to that, provides for people of religious persuasion to come together in community as a basic right. So when the minister must, as she says she must, make painful decisions about what to do, she must make those painful decisions in full cognizance of the importance of the religious right. After all, this is not animal farm. Some are not more equal than others. It is not so that those who are pursuing economic rights and economic interests are above those who are pursuing religious rights, particularly in the context of a pandemic, where the support and the guidance of the religious community plays such an important role for those who are in distress. And in this context, if Your Lordship will allow me just to make this comment, that the reliance on the Muhammad judgment is completely out of place in the present context. Because in Muhammad, what the court was confronted with was an equality. In Muhammad, everything was closed. And because everything was closed, Her Ladyship, Madam Justice Neukircher, said she couldn't make an exception for the religious community because everybody had to suffer the consequences. What we are confronted with here is exactly the opposite. Everybody else is allowed to engage in economic activity, and it is the religious community that is being told, but you are not equal. You can remain closed because we're trying to help other people, but we're not giving effect to your rights. So
why is that not rational? You may say it's discriminating. I'll come to that in a minute.
Yes.
Why is it not rational?
My Lord, because
Discrimination can be rational. Why is it not rational to say, I'm protecting someone's job, I'm preventing someone from being, I don't want to allow them to remain in work. I don't want to close down the restaurants.
Yes.
But I have to protect their work because then I protect them from being retrenched, from losing their houses and whatever else. That's the only reason I'm allowing this. In other words, as painful as this decision is for me to take, I'm going to take it, but that's because there was a concern I have, which I can't mitigate, the concern of them losing their jobs.
yes.
She
Now,
makes
my
that
Lord,
point a number of times in the affidavit. Why is that not rational?
yes.
I may not
My Lord,
make the same decision myself, but that's not the test.
my Lord, we are not saying, if I make this clear, we are not saying it's not rational for the minister to open economic activity. What we are saying is, once she opens economic activity, what is not rational is to say that under the same restrictions, religious activity cannot continue. So that's where the rationality problem in the inequality lies. Because if we accept,
situated, yes, but if they're not, she's not losing jobs there. She's not losing houses, and it's not people not losing their. I don't know. I've heard the argument made quite strongly yesterday about food parcels and all of that.
yes,
But I've heard all that argument.
but that's the very point, my Lord. And it's not only about the economic activity of the church. It is for the minister to act rationally. She must say that I am placing restrictions where I have no other option. And that is in relation to restaurants, that's in relation to casinos, that's in relation to taxis. And she must then also ask herself, do I have any other option in relation to the religious community? And she herself accepts that she does have another option, because in a previous iteration of the regulations, she was happy to keep economic activity more restricted and allow religious gatherings. Your Lordship will recall that initially restaurants were not allowed to open. They could only serve food for takeaway purposes, for example. Your Lordship will recall that at that time, gyms and casinos were not open at all. At that time, for example, nail bars and hair salons were not open at all. And in that time, the minister then thought it good, for the good of the community and the support that the religious gatherings gave, to allow them, although on restricted basis and under the protocols that she had prescribed. Now, rationally, once she accepted that there was a basis to do that, there is no rationality to then later, when she opens the economy more in the interest of the lives and the livelihoods of people, not to retain the religious gatherings under the restrictions on numbers and subject to the protocols that were in place. And that is simply the submission that we make on that. We say that there is a point of equality that must be linked to the rationality question. And in relation to this, for example, your Lordship will understand that some reliance is placed on the FETA case. Now, it's hardly can it be said that people have a right to smoke, and yet, I mean, this is the fundamental point. It is different when people are seeking to assert a fundamental right, like the freedom of religion right, versus something like access to liquor, or access to smoking, or some other activity. What cannot be left out of account here is we are dealing with a fundamental right, and a fundamental right that the Constitutional Court has said on more than one occasion is intimately linked with dignity, and with equality. And so effectively what the court has told us is when you tread lightly on those rights because they are so central to the human condition. It is in those circumstances where the minister, in order to act rationally, had to proceed extra carefully, and that which she did not do, and that which we ask your lordship to prevent from happening again. On the matter of costs, just in relation to my client, we do ask for costs in the notice of motion. We didn't make submissions on the costs issue in our heads of argument, but that should not be taken as an indication that my client is not pursuing costs. We are in agreement with my learned friend that the buyer watch principle applies. In other words, if we on the applicant's side of the table are successful in enforcing a constitutional right, then the costs should follow. But if we are unsuccessful in persuading your lordship of our case, then each party should pay their own costs in accordance with buyer watch. Those subject to any questions your lordship might have, those are our submissions.
Mr. Botha said everyone's working on pro-amico basis. Is that not true?
It's certainly not true on this side of the table. I am working on a reduced fee, but I'm not working pro bono. I don't know precisely what the situation is for all of the others.
Thank you.
As it pleases the board.
Thank you. Thank you. Ms. Martin.
Thank you, my lord. My lord, there are distinguishing features in terms of this particular application as against Mohammed, which have been touched upon by Ms. Engelbrecht. And I'd say the two foundational cornerstones that make it very different is obviously the differentiation between the faith-based organizations and the rest of the economy as the regulations that we've attacked. And then the other distinction, which we've really kind of impressed upon the court, is the ongoing criminalization of faith-based organizations in terms of meeting and gathering. And I'll take the court through that just briefly as against the Lawrence case and some of the submissions made by my opponent. But at the outset, my lord, and as against that backdrop, I would submit that the matter cannot be moot. And once again, I link this to what the minister herself states under oath, because that once again is a fundamental problem of the minister's case, where her case is very contradictory and very sparse in terms of a consistent argument. And I would even go so far to say that that marries with the regulations themselves in terms of the vagueness that we are met with. And what the minister says under oath, and this is an affidavit that has been filed for both ourselves as well as FORSA, is she files an affidavit on the 22nd of April 2021, and that is found on our case line 014-1, and I'll take the court through to that one. I'll just refer it.
Please.
If I can start at paragraphs 46 to 61, and what the minister states under oath is that she deals with mootness, but she makes no undertaking at this stage of the 22nd of April 2021 that once again, as per December, there's going to be an outright ban and there's going to be criminal sanction. And as Mr. Botha so lucidly put it yesterday, what happened in June, July is that she upped the ante. It went from being, you can't meet and please disperse them, policemen, if you find them, to arrest them. It's criminal and arrest them, whether they're the pastor or the congregant. And then she proceeds at paragraphs 88 to make this astonishing alternative request. She says, remedy. In the event that the court is persuaded to declare invalid either or both of the two regulations, I submit for the reasons that follow that an appropriate order would be one suspending the declaration of invalidity and affording me an opportunity to cure the defect. The two regulations form part of government's overall strategy to manage the COVID-19 epidemic. A change to one part of the strategy will have to be assessed in light of the broader purpose of the regulation. After all, the general strategy will remain the same, government wants to reduce the risk of spreading the virus. The applicant's relief will effectively permit large faith-based gatherings with limited restrictions in place. So what she states under oath, and I'm going to link this now to Esau, is she says, if there's a declaration of invalidity, I'll accept that. I not only have the power to amend those regulations, I have the power to then look at the underpinning strategy and policy informing those regulations. And she goes even further, my lord. She says what this will mean is that I can still restrict faith-based gatherings, but the court has informed me how. And this is an imperative concession on the part of the minister, my lord, because what she concedes is the possibility that this is still alive and well, because the underpinning strategy still exists. But what she also concedes is the court is entirely empowered.
But it's based, you know, it's the belts and braces case. She's saying my belt is that it's moot, but if I'm wrong on that, and only if I'm wrong, and then you're looking at the merits, and if you then find the merits are, I failed to meet the onus imposed upon me by the law, then only I ask that you give me an opportunity and to relook at it in the light of the comments made by yourself to the court. I can't see how she's contradicting herself. And the belts and braces arguments always has at face value an element of or an appearance of contradiction, but she's not contradicting herself.
My lord, I respectfully submit that that simply doesn't make sense as against the case on mootness, because what my learned friend has submitted to the court, and mootness in and of itself, what it implies is that there's no longer a
live issue,
controversy or prejudice or threat of prejudice. So the moment she says there's a possibility that I can go back and amend these regulations, they're not dead as a doornail, and I can go even further, and I can actually amend the strategy underpinning them, and I can go even further, and it will inform prospective regulations. That kills her argument dead in terms of mootness. And that is also informed by Sal, and I would refer the court in that regard to paragraphs 44 to 47 of the judgment, where they discuss this issue of the reviewability of policy, the ripeness of it in terms of when does it crystallize for a court to actually review the underlying strategy that she is talking about. Moving on from the mootness, my lord, I would also submit just one last point, that ties in line with international authority. Because not only do we have a SAL, which I'll take the court through now, in terms of the fact that COVID regulations are not moot, but this is what the Supreme Court of Appeal states in Cuomo, which I referred to yesterday in my opening address. The dissenting opinions argue that we should withhold relief because the relevant circumstances have now changed. After the applicants asked this court for relief, the governor reclassified the areas in question from orange to yellow, and this change means that the applicants may hold services at 50% of their maximum capacity. There is no justification for the proposed course of action. It is clear that this matter is not moot. An injunctive relief is still called for because the applicants remain under a constant threat that the area in question will be reclassified as red or orange. And that's found on case line 023-4. And it's noteworthy, my lord, that after stating this under oath, the mootness as against the alternative relief, that was 22 April 2021. We then fast track to June, July 2021, where once again there's an outright ban to the exclusion of the economic sector, and she ups the ante. With regards to then consultation, my lord, I would also like to refer the court to paragraphs 83 to 94 of the Assau judgment, because my learned friend, Ms. Engelbrecht, is perfectly correct. I submit that it would fall within the realm of administrative action. And what that means is that they have to follow fair consultation. And ESAU actually enumerates that. And what they talk about at paragraph 94, if I can go there, is the following. It talks about the concept of what is fair process in terms of consultation. And I know Force's heads of argument have also addressed this. It is notice and comment, public notice and public comment. And that is amplified and culminates at paragraph 94. Now, whether or not the minister says, because it's a pandemic, I need to have a restricted time period, it can only be 2 hours of public comment because we're moving so rapidly. That's within her purview. But what she cannot do is say to this court, I have vast terrains of applicants who want consultation, and I only feel like dealing with 5 people in the group, making up a MAC. That is not permitted, and that is what the SCA analyzes succinctly in terms of those particular paragraphs, my lord. Then, my lord, turning to the merits, like Ms. Engelbrecht's clients, simply do not have any scientific evidence attached to our application informing the regulations, particular to faith-based organizations. And what Cuomo says there as well, it's also instructive. And that's found at 023-4, where the Supreme Court of Appeal in that instance said in that jurisdiction, not only is there no evidence that the applicants have contributed to the spread of COVID-19, but there are many other less restrictive rules that could be adopted to minimize the risks to those attending religious services. Now, what is interesting about my learned friend submission in this regard is that he relies on 3 affidavits by Mr. Buthelezi and Professor Karim and another gentleman. Not a single one of those particular affidavits make reference to scientific data, particularly from, say, October 2020, when there are specific protocols in place, which I'll get to the faith-based community, leading to a COVID spread. In fact, what happens, if I can take the court once again to what was informing that decision from a faith-based perspective, because this is the only document, and it's not from the respondent, from the minister, we discover it. It is the only contemporaneous document from around December, January, informing that decision. And that is once again the South African Council of Churches document, which is found on case line 012-10, paginated page 491. And if I can just take the court
Zero there.
If
Zero.
012-10, paginated page 491, Annexure RA7. Now, this is the only document attached to all of these papers around the time informing the decision. And what happens is that at paginated page 492, paragraph 6, the minister is informed as follows, and the president. When the president first announced the new adjusted alert level 3 declaration at the end of December 2020, the SACC churches accepted that under the circumstances we could sustain 2 weeks of church lockdown. And when the president convened an interfaith consultation on January the 10th, very important because on January the 11th, we met with an extension, which we assumed was to revise the status as to the 2 weeks was coming to an end. At the consultation, SACC first vice president made the case for churches not to be treated differently from other sectors such as restaurants that can host up to 50 persons. We hoped that the January 10 consultation may impact on the provisions of any extension of the adjusted alert level 3. We sought to have the same provision of numbers that restaurants can have, where up to 50 attendants are admitted. And what happens, my lord, is that we file this document, and there's simply no response to it. Here she is informed from a faith-based perspective, not speculation, not we're in a pandemic. We all know we're in a pandemic. This is the only document that informs the minister, please treat us the same as the rest of the economy. And there's no explanation. She's quiet as to why she declined that request. It is patently irrational.
No.
My lord,
It doesn't explain it. And it is so, because she doesn't explain it, it's irrational. It seems to me that there is a lot of rationality in her argument, that I'm trying to save someone's job, much as I don't want them to go to work. I know they're at risk, but if I don't, they're going to lose their jobs and businesses are going to close down. I can't afford to have that.
but my lord, unfortunately, let's talk
And
about.
all the churches are saying to me, give me the same.
Yeah.
What more must I say in my document? Yes, I've heard you. You consulted me. You said that to me. But I've decided I can't. I'm not going to take that decision. That doesn't mean consultation means you had to give what the SACC asked for.
No, my lord, but what it,
You, Lord, they consult all the time for retrenchments. You don't have to agree with what you have to say.
what it means, my lord, is that unfortunately we have a situation of a government who has relegated a Section 15 fundamental right as being less important than going to get your hair done and your nails done. Less important than
They're not interested in you getting your hair done and
my
in you
lord,
getting your food. They're interested in the person who's who's going to lose the job if you don't come and do your hair.
But my
They're
lord,
interested in the economy coming to a standstill. They're not saying we're worried about you getting your nails done. They're saying we're worried about the person losing their jobs. You know, it was patently clear, and it's in her papers, that there was mass retrenchments. Hotels were consulting lawyers saying, we want to retrench 10,000, 5,000. She has to deal with that. She's got an economy to run. Or at least not she, but cabinet. In fact, it's a decision taken by cabinet, as Mr. Mokhagabe pointed out this morning, as part of the whole thing. She's just the one who promulgates it. But
well, my lord, if the court is not inclined,
she's not interested in the individual getting the service. She's not looking at the congregant who's being used on his own. She's saying, look, as a whole, I would like you to have it, but I can't. And for their sake, they're just lucky that I have to save my economy. That's rational.
It's not rational.
Irrational.
It's not rational for the following reason. If it's not an issue of faith, if it's not a question of that the faith is not important enough to consider even in terms of the time of a pandemic, there is another aspect to it, my lord.
Did she say that? Do you really think where in the papers would she say faith
I think it can be strongly
not important or less important than economics? Than the person getting the nail done. She may not have said it. She didn't say it's less important than economics, but she never said that the person going to pray is less important than the person going to get the nails done.
Well, my lord, I think that it can be inferred, because what she says is that this is about lives and livelihoods, and we're going to criminalize the church, but we're going to keep a whole host of economic activity open. What she forgets, and unfortunately it's a situation where this is just not coming across at all in terms of the analysis of her decision, is the fact that in terms of the Disaster Management Act, in conjunction with the Constitution, saving lives and livelihoods is not simply a situation of this sector going to church on a Sunday and praying. This is the sector that actually deals with the aftermath of the pandemic. This is the sector that deals ongoingly with the socioeconomic sector and the socioeconomic fallout. And my lord said yesterday, or I think it was the day before, well, can't you separate those out? These are not people who can. If they are feeding orphans, there is worship. If they are running a school, there is worship. And as my learned friend, Advocate Bouda said, this is a situation where all of those aspects have been taken out because of these types of regulations. And unfortunately, my lord, that is part of the overall disaster management life cycle, where governments are completely blindsided in terms of a sector that should be helping them. There are medical doctors who help the ill in the hospital. These are doctors for the aftermath. These are the doctors that help the socioeconomic impacts and fallout, far more than an economic sector focused on drawing a salary or running a good ship. These are the people who actually fill the gap, who plug the holes for government, and they are being excluded. They are not being consulted with on a public basis, and they are not being included in terms of less restrictive means to afford them and accommodate them the right to meet during a pandemic. And my Lord, with regards to that, it must be remembered, as per our affidavits, 80%, according to Stats SA, 80% of this country recognize themselves as holding a Christian faith. That's found on case 9007-0006 at paginated page 127, paragraph 102. And this notional concept of faith, my Lord, it transcends politics, it transcends economics. We have a plethora of applicants before this court from a range of different means, the poor, the rich, and they are all organized and they are all ready to actually fight for a Section 15 right, which is multi-dimensional. It's not only about going to church and worshiping. And even to that extent, my Lord, for example, another contradiction, and again, it falls within the realm of what Advocate Botha said so eloquently as against the De Lange case. The argument is believers can continue to practice their faith at home. In the same affidavit, the minister says, but they can't go to church because this notion is they'll hug, they'll kiss, they will share communion. It's mutually exclusive. We either have a faith where we meet or we don't have a faith that meets. It's mutually exclusive in terms of what she has stated. Second, lastly, my Lord, there is no evidence presented to the court by the minister that this disease is a disease that distinguishes between the secular and the holy. There's nothing saying to the court, if I go to a church or a mosque or a synagogue, it's going to be any more or less dangerous than going to a casino. My learned friend was asked, well, why the casinos? And his response was twofold. He said they are overseen by an administrative body, and secondly, they are overseen by protocols. With all due respect, my Lord, that is exactly the same as what is met with a faith-based organization. From October 2020, before they were criminalized on 2 separate occasions, they had extensive norms and standards which were regulations. And that is found at case line 012-0002, paginated page 399, paragraph 4.2.3. Exactly the same kind of protocols employed in casinos, in hairdressers, in nail salons, in restaurants. And there's no explanation as to that inconsistency. And as for the distinction of overseen by an administrative body, we have extensive administrative bodies in terms of the faith. And there's no evidence that any of those protocols were contravened, leading to some sort of spread after October 2020. And lastly, my Lord, just with regards to the Muhammad case, linking that once again to the time frame. The Muhammad case was decided on the 30th of April 2020, when the country came out of lockdown level 5 and 4. Once again, pursuant to that decision, from October 2020, there were strict protocols in place for churches, guidelines for churches. And that once again is found on 012-0002, paginated page 399. And once again, that material difference is not explained by the minister. Is there anything further that I can address the court on?
No, thank you, Mr.
Thank you very much, my Lord.
Thank you. Mr. Botha?
Thank you, my Lord. Advocate
Mr.
Botha
Botha? Is Mr. Botha not here?
Advocate Botha is in the room with us. He's delegated the responsibility to reply to both his juniors.
Well, then this is an important question on executive decision and administrative decision. You know, when an one circumstance to determine, I know I'm told that I'm bound by SL, so don't repeat that.
Want to ask me? Yes.
Can you tell whoever's in that room to remain quiet?
Be quiet, my lord.
Yeah. Normally, an admin decision is taken by the party or the body that is, or the individual that has the administrative powers, i.e., if you someone, you have to go to a body that gives you, that determines whether you're going to become an essential service or not. Or you go to a body that gives you a license to drive a car, or to give you a license to open a particular kind of business. That's that body's decision. And you apply their rules, and that body consults with nobody but applies. In a decision where you just promulgate something, but the decision is taken by a whole host of other people, where consultation is taken not by you, but by the president, that he does the consultations with some other bodies, that he comes to the party and he comes to the NCC or the National Command and then the Cabinet Committee. Is that not indicative of the fact that this is an executive decision, not an administrative one? Mr. Karolia?
My lord, I prepared basically on 2 points, one on mootness and one on executive action and administrative action. Now I've heard your lordship, but I'd just like to touch on this issue of administrative action and executive action by virtue of the example given by Commissioner Pali SC in her heads of argument. And this, your lordship will find at case lines on the MLA matter, it's section 54, page 115. And it moves on to page 116 as well. Your commissioner uses an example of the captain of the ship.
You mean Ms. Pillay?
Ms. Pillay.
Ms. Pillay, yes.
She uses an example.
Or your learned friend.
She uses an example of the helm of the ship where the captain determines the direction of the sail. So she distinguishes between the captain and the boilermakers at the bottom of the ship. So to say, who's making what decision and who's running that decision. Now, if I'd have to look at the current situation and considering the Disaster Management Act, there's two actions that's taken. One is the declaration of the state of disaster. The second action that's taken,
yes, I'm with you,
is the making of regulations. So we shouldn't lose sight of the fact that the minister is in effect making two decisions. And if we look at the first issue, the declaration of a state of disaster, now that obviously on the papers before court is not being challenged. But that, tying it up to the example contained in the state's heads of argument of the captain, that decision to steer the ship in the direction of the state of disaster, at best for the state, that could be the executive action. But when it comes to we need to do this, that, and the other to steer COVID in this direction, for that we implement legislation. And I must concur with all of my colleagues. The assumption says,
let me say this. That's correct. If she alone makes the regulations, if she has to consult nobody else amongst her colleagues, in other words, nobody else influences her decision except the representations she receives and the documents she looks at. But if somebody else is doing some of the work, I'll give you make a simple example, or make it slightly simpler for you. In new clicks, the pricing committee determines what the prices for medicines should be. They didn't eventually win. They lost, or they won on some of it. They lost on some other aspects. The pricing committee makes that, and they simply make a recommendation to the minister, and she makes her own decision. She's acting solely in terms of her legislation, taking part of a task to the body. But here, the minister is not making the decision herself. The decision is taken by a command council. The decision is taken in conjunction with the president. The president is part of making that decision. The cabinet is at least. His cabinet is. Then is that not executive? Is that
certainly
not indicative of it being executive?
No, definitely not. My lord, they've passed me the regulations itself, and the January 2021 regulation starts off by saying, I, Dr. Nkosazana Dlamini Zuma, Minister of Cooperative Governance and Traditional Affairs, designated under Section 3 of the Disaster Management Act, having declared a national state of disaster, published under Government Gazette, and the Gazette is cited, and extended, after consultation with the relevant cabinet members, makes the regulation in the schedule. So the actual decision taken is made by the minister herself.
But that's not what she says in her affidavit. In her article affidavit, which is not disputed, which Mr. Mokgakabe took us through this morning, but she talks about the whole process. And she talks about setting up a subcommittee as if they talk of as if that's a sort of subcommittee of the cabinet. I can't remember if he actually went that far. And then that committee is made up of a certain number of people. Then it takes it from there, and she gets all those people to make that decision. And then Mr. Mokgakabe made a fundamental point. He said, if she had to make her own decision, that would be fine. It might be administrative. But in this case, she can't do so without getting the agreement, I think he said, of the respective minister whose portfolio is affected by the decision. So she couldn't make the decision. And a good example of this is, if you went back to the early stage, it's stated in the Esau judgment, the actual minister who took the decision regarding the shoes and the food in it was not Minister Nkosazana Dlamini Zuma. Yes, it was promulgated by her, but was taken by the minister in DTI, the Department of Industry. So what we see here is not a classical admin decision that we all know about. It seems to be more multifaceted. It has other people taking decisions. She's just promulgating it. And while she's brought here to defend it, it's a decision taken by a number of people. Isn't that indicative of it being more than administrative, of it being an executive decision?
Now, Mr. Mokgakabe might have submitted that's on the papers, but I submit that based on the regulation itself, the decision taken is by the minister herself. So while it is correct that other ministers may make certain directions, food as an example, as your lordship alluded to, principle remains.
He made his own regulations, yeah. Okay, I hear you, Mr. Karolia.
So that, my lord, the further point that I'd like to deal with, and it's specific to the Muslim Lawyers Association, is the issue of mootness. Now, it's common cause that the regulation itself, and it's regulation 36 sub 18 of the January 2021 regulations, that specific regulation criminalizes the contravention of the gathering regulations. We've pleaded in our
June what, Mr.
January 2021 regulations, the impugned regulations. So the specific regulation which criminalizes the action is regulation 36 sub 18.
That's the June regulations.
January, 11 January 2021.
Wow.
Now, following from the criminal sanction contained in the regulations, arrests have been made two worshippers, and this the court will find at case lines on the MLA matter, section 7-6. It basically provides at paragraph 11 that we are instructed that our client is aware that a worshipper at the Avondale Musalla in brackets mosque has been arrested. This in addition to an individual in Pretoria. Now, why I make specific mention of the arrests of worshippers is that in the Batsa decision of the Western Cape High Court, the court at paragraph 27.5 of its judgment basically states that the matter is of importance, of great importance, not only to the parties before court, but also to the public. And where the public comes into play is that in relation to criminal sanctions. Now, worshippers have been arrested. It's not moot, because if this court finds that the regulations are unconstitutional, then worshippers have been arrested or subject to arrested in terms of unconstitutional regulations. So the outcome of this may very well determine whether worshippers who have been arrested have claims against the state, unlawful arrest, detention.
So you've been frozen. What the rule, yeah?
Yes, my lord?
The outcome of this will
determine whether worshippers who have been arrested, or in actual fact, anybody in the country who's been arrested as a result of these regulations, whether they have claims against the state in relation to unlawful arrest, unlawful detention, those type of claims. So based on the Batsa decision,
this court already say, if it says that, then it has already dealt with the unlawfulness of the arrest in that case. But that should be a matter for that case, because we don't know anything what's going to happen there. Normally, using the Hollington versus Youthon case, anything we say, unless, of course, our orders, any opinions we grant are nothing but opinions. But orders, of course, are not. If we declare it unconstitutional, as you're saying we have, then automatically that arrest, the unlawfulness element of that arrest, has been already attended to by this court. That's your point.
So I'm not going into the prospects of success of the unlawful arrest claim. What I'm saying, as it stands, if the regulations are declared valid, it may be that all those arrests, to the extent that there have been a contravention, those arrests are in accordance with the law. But to the extent that this court says the regulations are unconstitutional, then the person who's been arrested or convicted can then think to himself and say, but look, I've now been convicted in accordance with a law that's been declared unconstitutional. So what follows from that is the individual himself or herself then has legal recourse, whether he seeks to review any decision of the arrest, challenge it on appeal, whatever it may be. They may then decide, well, I want to institute a necessary action against the Minister of Police. That right then remains. It in actual fact enhances such a right to proceed.
But we lose this if this case goes against him?
That's why exactly the matter is not moot, because that issue needs to be determined to determine what happens with their matters, and BATSA is authority for the submission. So apart from everything else, just on BATSA and the arrest that we've pleaded, the matter is simply not moot. If your lordship has anything further, I'd hand over to my colleague.
What do you have to say on the mootness point? What do you have to say to the argument that the facts upon which that were available at the time that made them take that decision are not the facts that's going to be available at the time when they make the next decision, if they decide to prohibit religious or faith-based gatherings?
My lord, I haven't.
Would not mean, as Mr. Mokhabe submitted by reference to those two cases, I think Marudin or something was it? There were two cases Langeberg and Normadine, I think.
The ability to change the regulations at any stage dependent on the circumstances at
In other
hand.
words, your factual matrix has changed. Does that not make a matter moot?
No, I'm of the opinion that the fact that they can change regulations at any stage dependent on the circumstances makes the matter not moot. Now, in hand, if I can direct your Lordship's attention to case lines, the MLA matter, it's section 25-34. Now, at paragraph 87, the mischief that's apparent by the minister in pulling the rug suddenly on the 1st of February, the day before the urgent application was set to be heard, is apparent from this specific paragraph. Now, 87 basically states, and this is in the minister's affidavit, government is closely monitoring the situation and reviewing the prohibition. If in fact, after a careful and thorough risk analysis, it appears that it is safe to lift restrictions, government will undoubtedly ensure a move to a lower alert level. So what this paragraph contemplates is that the government is giving thought to this, and should something happen, we'll do X, Y, and Z. Now, the court is to have regard to the fact that this affidavit was deposed to on the 30th of January, 2021. We were in court for the urgent application on the 1st of February. Now, in this paragraph, the minister doesn't say, look, we're currently in a meeting as I depose to this affidavit and circumstances may change. That's not what the minister says. The minister says, should something occur in the future justifying a change, we'll do it. So we can accept from this paragraph on a literal reading that nothing has occurred on the 30th of January. But what happens? The mischief becomes apparent, you amend the regulations, and then the urgency falls away. In a similar way, we could launch extensive applications, and suddenly the day before you get to court, they amend the regulations, and suddenly the matter is moot.
Yeah, so what's wrong with that? Listen to this proposition.
The principal issue is
an application that you must restore the water at my home. Or I bring an application that you must return the child to me. You must return the child to me, and if you know by a certain time, just before we get to court, or as we get on to court, I either restore the water or I return the child. It happens all the time. So what?
But
the application fell away. You may want to argue your costs. You may want to argue costs, but the fact of the matter is the relief you are seeking is no longer live.
But the implications are for the specific one individual. In this case, we have a public at large, the populace, the religious populace of the country that's affected. And,
So,
in the examples of the return of the children and the restoration of water is a matter of a once-off incident. That we're in a COVID pandemic.
But let's take the water and the child example as well. Nobody stops you. Nobody knows that you're not going to take the child away again. Or, put it differently, let's leave the child one out. Let's go to, or we can still seek the child. Nobody knows that he's not going to return the child next week. And nobody knows that they're not going to cut the water off next week. And next week they come again. So they'll say, you say, but you might cut my water off next week. You say, yeah, I might. It depends what you do. I'm putting your water back, and I'm now asking you, please in future don't do this. But if you do that again, then I'm going to cut it off again. Now, there's new facts, and you do something. He says, no, there's new facts. Then he can defend it. So as and well, given the fluidity of the situation, as things change, they may change the regulations as they wish. As things change, and if the change falls, if the X falls alongside your case, in other words, if the X falls on your case, it results in you not having a live issue, your relief no longer can be given or need be given, then it's moot. It doesn't matter what her motive was. Doesn't matter that she tried to, what you use the word, pull the rug, I think, is the word we use. You know, maybe that's her motive. Maybe it was ill. I mean, maybe she had an ill motive. Then all you do is you mark her with costs. It happens every single day in court.
But the reality to the facts at hand is that the court is tasked with dealing with principal issues. One obviously being, is it executive or administrative? The relevance of the rationality, the treatment of religion over other interests. That cannot be tied up to the examples by your lordship.
Why?
They're vastly different because those principles may or may not come into play in the other matters. And I submit that on a simple example of the water, the issues are not as in this matter. And at case line section 27, section 27, pages 6 and 7 deals with this issue of mootness. And at paragraph 11.3, 11.4 of our heads of argument, we clearly state that you've got to look at the importance of the issue, the complexity of the issue, the fullness or otherwise of the arguments advanced. Now, I think nobody can disagree in regards to the fullness of the arguments advanced. I mean, that's why we're here 3 days into the hearing. Because if it was a simple issue of something else, the issues wouldn't be simple as what we have. So I'll submit that, my lord, the issue is most certainly not moot. And it entails important public principles.
Thank you.
My lord, I'm going to hand over then to my learned colleague, Advocate Umar, who will deal with the further 2 points.
What were the 2 points is left? Advocate Umar, what's the points?
I'm sorry, my lord, the echo, we just want to deal with that.
What are the 2 points you're dealing with?
My lord, 2 issues have somewhat become blurred as a result of submissions on behalf of the state. And the first relates to the issue regarding discrimination, and the second relates to the pleadings. Both of those issues, your lordship will recall, our learned senior, Mr. Boda, made submissions on them. My lord, I don't intend to be very long on these issues. I want to refer to the judgments in Harkson versus Lane. It's just 1 paragraph. And the judgment, the National Coalition is being referred to, my lord, and then there's the judgment in Pele. If your lordship will allow me very quickly, I'll put it up on screen, but I don't intend to be very long.
What's your discrimination argument? Who are you discriminated against?
My lord, it's important that we go back to the principle as enunciated in Harkson versus Lane. And I'll show your lordship where the discrimination comes in and why we say the state has got no answer to it. My lord, if the court will allow me, I just want to put the judgment up on screen. I'm not sure if your lordship can see the...
I can see it, yes.
As you go, please. My lord, if we look at paragraph 44 of the judgment in Harkson versus Lane, and it's the final sentence, in fact, in paragraph 44, the court says, and I've highlighted it in green, if there is such a rational connection, then it becomes necessary to proceed to the provisions of section 8.2 to determine whether, despite such rationality, the differentiation nonetheless amounts to unfair discrimination. The point is quite simply, my lord, that rationality is not a defense to discrimination. Rationality does not exclude or absolve the state of discharging its obligation as far as the fairness requirement is concerned. And my lord, if we look at paragraph 18 of National Coalition, the court also confirmed that rationality is not a defense. So the point is, it's quite conceivable that a decision or the regulations could be rational in that there's a connection between the measure and its purpose, but that it must be struck down because it's discriminatory in that it doesn't comply with the requirements as set out in Harkson versus Lane. And my lord, once we appreciate that the principle from Harkson versus Lane is rationality is not a defense to discrimination, we then move on to the question of fairness or unfairness. And I want to then take the court to the judgment in Pillay from the Constitutional Court. I'm sure your lordship by now has the citation, but I put it up on screen also. And specifically paragraph 72 of that judgment, my lord. It's important to note, for the purposes of this submission, my lord, Pillay, it starts off by dealing with the question of unfairness in paragraph 72, and then it deals with the issue of deference. And your lordship will recall there was a short debate between your lordship and our senior, Mr. Boda, regarding the issue of deference, so I'll get to that as well. But under paragraph 72, and I'm getting there shortly, my lord. Under paragraph 72, we see it's under the heading unfairness. I've highlighted it in green, my lord. And in paragraph 72, the court says the concept of reasonable accommodation is not new to our law. This court has repeatedly expressed the need for reasonable accommodation when considering matters of religion. My lord, and this will tie in with the latest submission regarding the pleadings, but it's our submission that there is no evidence on these pleadings that they've done this. Your lordship will recall this, and as I'll show it very shortly, the one reason put up in the answering affidavit to the MLA application is that religious gatherings, and it's very important, they say it's a potential super spreader. And then it appears that my learned friend on behalf of the state, our learned senior on behalf of the state, submits in the FOSA affidavit that, well, it is the core of their case that the economy must open up or there's deference to the right to earn an income, etc. But to that extent, my lord, there's a vacillation between the versions, but I'll deal with that shortly. The point is, reasonable accommodation is still very much something which the state was obliged to consider, being the actor who was depriving or diminishing the right that existed pre-COVID or in a different level for that matter. We then move under the heading deference in paragraph 81, my lord. And under the heading, we see, I just want to show, my lord, I've highlighted in purple, this is now under the heading of deference, and this is a debate which your lordship and our senior, Mr. Boda, took up earlier during the hearing. But under paragraph 81, again, it's the final two sentences of this paragraph, and the court said this court cannot abdicate its duty by deferring to the school's view on the requirements of fairness. That approach is obviously incorrect for the further reason that it is for the school to show that discrimination was fair. A court cannot defer to the view of a party concerning a contention that the same party is bound to prove. So, my lord, it's not with respect the question of deference to the minister's policy. And with respect, my lord, might I say respectfully, to suggest that the minister's policy decision is immune from constitutional scrutiny, more especially in a discrimination debate, with respect, it would be an unconstitutional approach to suggest that because it's a policy decision, the court doesn't have a discretion to consider the question of fairness, or for the court to say that it's a question of deference. The court, in fact, has a duty to enter that realm. My lord, moving on, the second issue, which with respect was slightly blurred as a result of the submission from the state, and I say so with the greatest of respect, is the issue regarding the pleadings and particularity. My lord, I want to refer you to the judgment in De Beer, and your lordship will recall there was much controversy about this judgment. It emanated from the Pretoria High Court, and Judge Davis was heavily criticized because of the lack of particularity in pleadings. Now, my lord, in paragraph 96 of the De Beer judgment, which I've put up on screen, the court is referring to the judgment of Public Servants Association versus Head of Department Health Gauteng and others, the Constitutional Court. And the citation, my lord, is 2017 ZACC 45, BC 2018 2. My lord, the judgment is the quotation from the judgment is included in paragraph 96 of De Beer, but the important part is the highlighted portion in paragraph 96. But perhaps I must read the entire quotation, my lord. It's very short. It says, orders of constitutional invalidity have a reach that extends beyond the parties to a case where a claim for the declaration of invalidity is made. But more importantly, these orders intrude, albeit in a constitutionally permissible manner, into the domain of legislature. The granting of these orders is a serious matter, and they should be issued only where the requirements of the Constitution for review of the exercise of legislative powers have been met. This is the important part, my lord, that we must emphasize, and I'll show you, lordship, shortly with reference to the pleadings, why it's important. The Constitutional Court says holding parties to pleadings is not pedantry. It is an integral part of the principle of legal certainty, which is an element of the rule of law. One of the values on which our Constitution is founded. Every party contemplating a constitutional challenge should know the requirements it needs to satisfy, and every other party likely to be affected by the relief sought must know precisely the case it is expected to meet. And then, my lord, at the end of paragraph 97, had a properly pleaded case been advanced, no doubt the minister would have been expected to put up the necessary evidence to justify the regulations. So at that point, my lord, if a proper constitutional case is pleaded, the pendulum swings the other way, and now the onus is on the minister. It says the minister is then expected to put up the necessary evidence, and I'll show you why it's not so. But then, to move on, my lord, with reference to the pleadings, in paragraph 46.5 of the founding affidavit in the MLA application, we deal with the issue of people remaining in casinos for extended periods. My lord, I just want to come back onto screen. I apologize. My lord, in paragraph 46.5 of the founding affidavit, we deal with the issue of people remaining in casinos for extended periods. And we say that although the protocols of wearing the mask might initially be followed, eventually it comes off. We say that the behavior in casinos increases the risk of transmitting the virus. The state's response, very importantly, my lord, to this allegation is contained in paragraph 81 of their answering affidavit. They do not deal with the substance of the complaint.
Discrimination argument that you needed to be treated the same as restaurants, casinos, and other, well, some people use taxis. But is that your case? The differentiation is between you practicing a religion, gathering for religious activities, a religious gathering, and them coming to exercise economic activities.
My lord, the discrimination case emanates from the following question. How is it, or what evidence do they rely on, that the same measures which are used in casinos and cinemas...
They don't say. They've never said that it won't spread. They're accepting that it might spread. It's a risk they had to take because, or an unpalatable decision they had to make because of economic activity. Now, what is your comparator for unfair discrimination?
My lord, the mosque on the left-hand side,
being discriminated against.
my lord, the masjid on the left-hand side is a building. It's owned by the Waqf or the trust. The building at the casino is owned by the casino or whoever the large corporate is. So they can continue under measures, but we cannot.
Your comparator is the engagement in, even across the masjid, there's a McDonald's there. And they allowed to eat, yeah, fine. Even the
why will the measures be effective in the casino, but not effective in the mosque? And they don't put that evidence up, Lord. That's the difficulty.
I understand it is, if she could stop it in the casino, she would.
No, but my lord, we're not dealing with
level 5,
stopping the spread. Everyone accepts that it's a question of flattening the curve. It's a gradual fight, which we hope to win to keep the numbers down. Why will the measures that are used in the casinos and in the cinemas not be effective enough to allow people to go in the reduced numbers?
You've just said it's not effective in the casinos as well. And she's accepted.
But does that not then demonstrate the arbitrariness in the decision? And that's why the question of the evidence in the record becomes a bigger problem for the state. Because if there was a scientific answer to this, that well, the virus attacks you worse when you pray in God in church.
Casinos. It might spread from the casinos. It spreads from the restaurants. She doesn't start. She can't deny that.
But my lord, then the end of the case for the state, my lord.
Huh?
That should be the end of the case for the state, because we're not asking for an indulgence beyond what's already given. My Lord,
I've heard you, Mr. Abubakar.
There's a further issue as far as the pleadings is concerned, which I want to continue to make, and I won't be much longer. But my Lord, we say they don't, and we make this submission against the backdrop of what De Beer requires in a case regarding a constitutional attack. And we say that they don't deal with the substance of the complaint. As far as the doctor that we rely on, the virologist we rely on, my Lord, they criticize him regarding his, the deponent criticizes him regarding his qualification, but that doesn't take the matter further. The state does not respond by putting up the empirical evidence.
She's got her Kareem, her Mahdi, all those people are on her committee, they're all her virologists. She said I rely on their expert evidence.
My Lord, that's well and good for the newspaper articles, my Lord, but it's not pleaded before you, and that's the difficulty we have. That's the difficulty Judge Davis had. That's the difficulty the SCA had. The court says, put the pleadings up and let's decide the matter on the pleadings. It's well and good to say, take judicial notice of the fact that Dr. Modi is consulted and Professor Kareem is. Where is it pleaded in this matter? We raise the specific issue, my Lord. We say, where is the scientific evidence to justify that it's legal to go to the casino and it's illegal to go there because the measures will not work or they'll be ineffective? It's a simple question of reasonable accommodation. Allow them to wear masks. There's a short period of time that they attend. Why can't they go? It's patently irrational, my Lord. But it doesn't go to the question of rationality. It goes to the question of justification and reasonableness, my Lord. My Lord, will your Lordship allow me a moment to confer with my senior? There appears to be something that I'm missing, my Lord.
Mr. Umar, do you want to come back after Ms.
My Lord, thank you for the indulgence, my Lord. My Lord, as far as discrimination is concerned, we say that the use of premises is proscribed based on the activity at the premises, and it's criminalized. Even without a comparator, you prohibit someone from using the premises based on his activity, which is his religious activity. It's direct discrimination. You don't need a comparator, with respect, my Lord.
No, man.
My Lord,
how do you get a discrimination without a comparator?
But my Lord, in this case, for example, if someone makes a racist comment, it's discriminatory. You don't need a comparator. With respect,
Really?
my Lord.
Really? A racist comment is discriminatory.
Of course, based on race or religion, my Lord. My Lord, can I ask that we stand by that submission, and perhaps maybe
I'll think very carefully about it, Mr. Umar. I'll consider that submission very carefully. Rest assured, I will give it a lot of thought.
My Lord, two further issues on the founding affidavit and the answering affidavit, very short. In paragraph 69 of the founding affidavit, we point out the exemptions in respect of economic interest and commercial interest and the uneven treatment of religious interest And we say it's clearly irrational. In paragraph 99 of the answering affidavit, they simply deny that the restrictions are irrational. In paragraph 103 of the answering affidavit, the state is emphatic, and this is with respect where I conclude, my lord. The state's case is said to be that government is carefully considering the situation and has identified all faith-based gatherings as potential super spreader events. The state's case as pleaded is not, at least in the MLA application, it's not that casinos are allowed to continue, for example, because they allow people to earn their income. And with respect, therein comes the vacillation of versions, my lord. The state says on one hand, in our affidavit, they are potential super spreaders. They don't put up the evidence to say they're potential super spreaders. And now they tell you, my lord, they jump onto, with respect, jump onto your lordship's submission or to your lordship's contention that they are permitted because they allow you to earn your income. They must be held to the pleadings.
I thought it's there in their papers.
And that's why I take your lordship to the answering affidavit in the MLA application. It's there in the FOSA application, but it's rather laconic, my lord. Because what they do is they say, our reaction to the COVID pandemic is to work on a risk-adjusted strategy and to collaborate with the economic and religious sector, and to then slowly open up the economy. But that's not a response to why are you permitting casinos and cinemas with measures, but you don't allow us. And my lord, perhaps the final thing, and my learned senior points out to me, the imam and the muaddin who call out the adhan, the call to prayer at the mosque, they earn an income. They've been forgotten in the system, my lord. So as much as everyone else is, and it cannot be collateral damage, my lord, because in the diverse country that we come from, my lord, to forget minorities, it would be tragic, my lord.
We should have.
My lord, we're not insensitive to the minister's situation,
Well,
but Isao is very clear.
Anybody who does labor law should know that the devastation caused by the retrenchments, anybody who does labor law should know that devastation.
My lord, there are large mosques in the country, or masajid in the country. If we think about the Hilal Masjid in Overport, if we think about the massive masajid in Cape Town, we've got imams, we've got muazzin that are there. They earn their income. They would also suffer by retrenchments. In Cape Town, masajid were locked beyond when government said they should lock it down. How would they earn income?
They're going to be dismissed because
they'd be retrenched.
Because we had a level 5 lockdown.
No, my lord. My point is, my lord,
one of them that was retrenched in the level 5 lockdown.
My lord, perhaps it's,
I can show you, but
an intriguing debate for us for another day, but not pleaded.
Loads, a lot of people, and she says it in her paper. She says a lot of people lost their jobs. A lot of businesses closed down because of the level 5 lockdown. Does she not say that?
She does say that.
Then tell me there's one person who lost his job or did not receive his income.
Is the court posing a question? Can I tell the court?
Can you tell me one person who was retrenched?
My lord, I might have to take names of masajid and I'll be in problems after this matter, my lord, because it's not pleaded. But if it was pleaded, we would have taken it up. My lord, let me make this submission. At the stage when we went into restrictions that religious gatherings were permitted, we were in December of 2020. We were approximately 1 year into the pandemic. Advancements were made regarding the vaccine. Yeah. It wasn't as if there was no scientific evidence. We were in level 3. We were not dealing with an ignorant or a suffering government or medical society for that matter. We were at a stage where measures could be implemented to manage it. We're saying, give us reasonable accommodation.
Yeah. Okay.
As the court pleases.
Thank you.
Thank you.
Last speaker.
My lord, I won't be quite the last speaker. Mr. Willis is going to deal with one issue after me. So close, but quite not there. My lord, I'm going to start with the issue of mootness because my learned colleague for the minister...
Everybody wants to do mootness. Anyway,
yes.
Yeah.
My lord, I will come to the questions that you've debated because to be honest, I think the mootness issue is easier and I'd like to get it out of the way. My lord, if we take a step back, and your lordship referred to Bishop Desmond Tutu during the bad old days of apartheid. My lord, one of the issues there was that we had a parliamentary supremacy. In other words, we had a unipolar state. In other words, the parliament could do what we like. We moved to a situation where we had constitutional supremacy, and that set up the separation of powers, the judiciary, the parliament, and the executive. My lord, with the triggering of the DMA, we went down to a bipolar state. In other words, the parliament had no say in the regulations and were not able, in terms of that statute, to oversee the executive in any sort of way. So what we are left with is judicial review of the executive's actions. Now, if we look at this particular case and how it's been pursued by the minister, what have they done? They've come here and they've argued mootness for most of the argument and then barely dealt with the regulations. And my lord, I'm going to put it to you that this is a pattern, and I'll show it to you, and the effect of it. And if your lordship accepts that this matter is moot, what we will have is an executive without any form of check or balance, which is the very essence of the separation of powers. So let's look at what happened. My learned colleague for the minister said, well, this is a short, this was a very short period. But my lord, it was traditionally, my lord, the president addressed us on a Sunday night. On Monday, the 1st of February, he changed the regulations and reopened churches. And we were in church, in court. Pardon me, my lord. Maybe a Freudian slip there, but we were. My lord, I'm not confessing to any sort of crime, but
yes.
Be that as it may, my lord, we were in court the next morning to seek an order that those regulations were unconstitutional. So literally on the court's doorstep, the regulations are changed. If we go back to the Liberty Fighters matter, one of the reasons that case became so problematic, and that's apparent from paragraph 3 of His Lordship Davis's judgment, is that while they were arguing the matter, the regulations changed. And here again, and there's a case I would like to refer your lordship to, is the sorry, I'm just scrolling up. The Skole Ondersteuningssentrum NPC, Bronkhieland Kleuterschool, and Solidarity, case number 24258 of 2020. My lord, it has been uploaded onto case lines, but I want to refer your lordship, and maybe I'll see if I can share the matter. Yeah, this is the submission.
65D3. The 65D3 is a point of law, isn't it?
Yes, it was delivered in terms of that. It was a notice delivered, but I want to.
That's the equivalent of a point in limine in an action proceedings.
Yes, and basically what the regulations have changed. This is a submission from an amicus curiae. So the first and third respondents, these were ministers for the sole purpose of disarming the court from adjudicating over the matter at the very last minute, and thereby leaving the applicants without legal recourse, without warning or notice. And then, my lord, further down, I'm going to take you, pardon me for my scrolling. I think I'm in the paragraph 48. Pardon me, I'm just finding the spot. And here again, it is very, at paragraph 28, it's very evident from this latest circular issued and distributed that the administrative actions of the third respondent, and by implication the first respondent who's simply following a lead, are an ever-moving target. My Lord, that is, with respect, that is the point that I'm trying to make, is that if the if your lordship is not inclined to deal with this with these regulations, then no one ever can. No one will ever be able to scrutinize the actions of the executive.
I mean, you basically, for me to come to that conclusion, I have to accept that there's a mala fide on the part of the minister and or the cabinet or whoever by amending the regulations on the eve, as Advocate Engelbrecht pointed out, on the eve of the hearing.
My Lord, if I may.
On what basis? Because it's ever-moving target, it's tenancy.
Yeah.
They'll do it all the time. We'll never hear their case. Because
Yes.
if maybe have to come to court, they'll change it tomorrow. Well, someone does that with putting water back. Someone does it with returning of a child. All you do is mulct them with costs.
My Lord, but this is, to be honest, this is much more important than any of these because it's a restriction of a constitutional right. So if we look at the AfriForum case, both Collip and Jay and the SCA grasped the nettle of dealing with these matters because they understood that it's important for our democracy that there be proper scrutiny of the executive. If the parliament can't do it because they're disqualified by the act, then it has to be the court, my lord. So I'm not asking you to find.
The point is the court only deals with live issues based on, and it will allow the matter to continue. The factual matrix is the same. Now, are we changing that law then? Are we now changing the law on mootness?
My lord?
If we're doing so, then I think we're also duty-bound to say we're now looking at mootness differently.
My lord, even my learned colleague for the minister admitted that you can hear this matter on the interests of justice. His argument is that you shouldn't. So your lordship is entitled to deal with this matter. And my argument is that very few, the only matters that have actually been dealt with are those where the courts have agreed to hear the matter on the interests of justice. If not, they're elusive, they disappear, the regulations change. And I think it's very, very important when the executive is unilaterally limiting the rights of constitutional rights of people that it be subject to scrutiny. Now, my lord, if we look at the if we look at the conduct of this matter from the beginning, we started with a morning-long argument about whether affidavits should be admitted or not. Eventually, in order to force this matter to go ahead, my client or we withdrew both our affidavits, my lord, and that goes to show that my lord, there seems to be a stratagem, and it's evident from our learned colleague the way he argued the matter that he's trying to avoid the scrutiny that comes if on the actual matter itself, the merits of the matter. So they've taken a procedural issue, they take it again and again. I accept that, but my lord, the bottom line is if we ever want to know whether this is constitutional or not, whether it's appropriate or not, the only place we can get redress, and our 14 or 11 million people we represent, is if the court grasps the nettle, as they've done in Essau, in AfriForum, where courts, and my lord, I would argue that considering that the SCA has twice grasped the nettle, that your lordship is, if anything, bound by that as well. The bottom line is that this is...
No, there's no ratio decidendi there. This is the decision taken by them saying, in our case, we want to do so. There's no ratio decidendi that arises from that on this point.
My Lord, I would submit that if as an Augusta court as the SCA grasped the nettle, that it's important that other courts do too. It's in the interest of justice. My Lord, we live.
Yeah, I can see the persuasiveness of the point, but I can't see the stare decisis of the point.
My Lord, then maybe I misspoke. I certainly meant the persuasiveness.
Yes. No,
So
I thought I'm bound by it.
No.
I
apologize. I concede, my Lord, I should have used the word persuasive, but I would argue that it's very persuasive, that there are two matters. Let's take the AfriForum matter. All that money was paid out already. If ever there was a matter where an argument for mootness could be made, surely that would be it. The money's gone. They all say the money, we don't expect you to change anything, take money out, but it's in the interests of justice that these decisions be made and dealt with. And I would argue that the SCA has done that twice, and that should be of tremendous persuasiveness to your lordship, because these are important issues. These are constitutional issues that where millions of people's constitutional rights are limited, and without the courts we have no scrutiny. So I would argue that you don't need to find that they're trying to duck and dive. I would argue that all you need to do is accept that since the religious, if we look at it, the religious freedom rights have been limited, and that just on that there should be scrutiny. The only scrutiny is going to come from your lordship, nowhere else. And
so what does it do to the law on mootness?
My lord, I would suggest it keeps it exactly the same, because the SCA has twice now agreed to step in, and so whatever that the SCA felt it appropriate to act suggests that is the law, or certainly that should be the approach of courts.
Okay.
My lord, so I would argue that the minister's argument on mootness is a non-starter. I would argue that this is an extremely important matter, that it's in the interest of justice that this matter be settled. And my lord, without a decision here, we will never know whether this limitation was constitutional or not. The second
mootness is a mootness finding not appealable.
My lord, but this would be appealable.
Yes, a mootness finding would be appealable.
Yes, it would be appealable, but my
final decision. It's not an interlocutory decision.
No. It's a final. It's a final order. Yes. So it would be appealable. It
could result in, as we asked Mr. Mokhagabe, what order will flow from there? The order will be that the applications are dismissed. Well, then that's final, isn't
it? My lord, I would argue in light of the interests here, and I'm going to add a further argument to this, is that in paragraph, I think it's 5 of my learned colleague for the state's heads, he concedes that the RAS is still in place. The risk-adjusted strategy. So as of right now, there is a risk-adjusted strategy in place. That we still have a state of disaster, and the minister may still limit constitutional rights. And I think that the clincher here is that Mr. Mokhagabe convinced me that this matter isn't moot. Because your lordship asked him, will the minister do this again? And he gave you a 3-part answer. And if he had just said no, the minister won't do this again, then we would be in serious trouble. but I listened very, very carefully, and he never said no. He said his three parts were a bit this, a bit that, and give him his due, my lord. He could easily have said no, and to his credit, he didn't. He danced like any good senior counsel should when they asked a question that is awkward. He never said no. If the minister was going to say, I accept, I'm never going to treat you differently to restaurants, to casinos, etc., that would be the end of the matter. So, my lord, unless there's anything more on mootness, may I move to the next point?
Yes.
Okay. My lord, the next point is the justification and the rationality of this matter. Now, my lord, if we look, and I'd like to use a hypothetical person here. If we look at someone who gets out of bed on a Monday and he gets into a taxi, and here, your lordship, I would like you to direct you to 001/103 of our papers. I believe it's at paragraph 11. And here we include an article where Professor Mardi made it clear that the government's COVID taxi regulations allowing for 100% seating in taxis for so-called short trips cannot be backed up by science, and that it will do nothing to stop the spread of COVID. So, my lord, what we have is a situation here is we have a regulation that's in place at the time when no one is allowed to go to church. It will do nothing to stop COVID. In fact, to be frank, COVID is almost certainly to spread in taxis. That same man then goes to work all day, and then he goes to a restaurant, and he eats. He takes off his mask. Now, my lord, I've never seen anyone eat with their mask on. Everyone takes their mask on the restaurant.
I'm going to wait for someone to do that.
My lord, I'd love to see it, and that's the
Maybe
point.
we should be the first to try it.
Yes, but the point is that would be the extreme exception. So then he goes home in a taxi. Then he gets into the taxi again, and he goes to work again. Then he goes to the casino. Then the following day, and he gets back into that taxi. He gets into the taxi, he goes to work, and he goes to gym, and he gets back into the taxi. And then he so on and so forth. But Sunday he stays home, but his father goes to church for an hour and a half, keeps his mask on the whole time, and never ever, and keeps his social distancing. My lord, which would have the greatest spreader effect? And let's look at the actual effect of the regulations. The regulations as they stood.
I said this many times. The minister has not denied anything you people have said.
Yes.
He said, I'm forced to do it.
Yes, my lord. But
all the cases, she's never, the presentation of her being uber irrational doesn't make sense to me. Or
my lord,
require uber rationality from her. It's silly, not making sense to me. She's never denied all of these things.
My lord, so let's.
Her case has never been that they don't spread. Her case has never been that they're safer than than churches. It has never been. There's that affidavit. Look at it carefully. It's never been any of that.
My lord, in fact, what she says is, she speaks about clapping and hugging but my lord, the bottom line is.
Yes, she does say that.
Yes, but that is her sole justification for closing churches. That is the long and the short of the papers that we do.
She has never said that there's no spread in the taxis, in the casinos, and in the restaurants. For
Yes, but
some reason, the three groupings have all latched onto these restaurants, casinos, and nobody said about why does she allow the petrol attendants to go to work. Nobody has said why does she allow. For some reason, these three activities seems to have caused a great deal of consternation amongst the applicants. I don't know if they thought this was the weak link in the minister's regulations. But she's allowed all sorts of economic activities. Some where the spread the risk of spread is even higher than in I'm sure in casinos than in. For some reason, casinos seems to have a huge problem.
My lord,
constantly being referred to in this case, in argument all the time.
my lord, if I may suggest why that is. The reason is that under level 3, an adjusted level 3, in June and July last year, roughly, I forget the exact dates, churches and religious institutions were opened and those institutions were closed. Then in December, the minister reverses that position. She keeps them open, but she closes churches.
Okay.
And she never, pardon?
So that's the reason.
So she and here's the key: is she never explains the rationale behind that. She never says, "I closed the churches because of super spreader events. I closed them because of this." She just says they clap hands. And so here we are. She makes a decision. I would hope it was rational. That churches are safer than those institutions, and then she reverses that. And she never explains her rationale for that. We never get a reason. She just says, I've decided. Fiat from on high, from the executive, without any, and to top it all, and is that we represent at the time 15 million people, and she just doesn't want to talk to us. She refuses to talk to us. Surely she should tell us, I've changed my mind in such a material way. Surely that's the essence of accountability. We've moved from a system where the executive and the legislature did what they like, where they have a responsibility to all the people. If you're going to make such a decision, then surely you should explain to 15 million people why you've changed your mind, why you're removing their rights away. And so if we look at this matter, my lord, I would submit that in order for the minister to succeed, she needs to show us why churches are now suddenly more dangerous than restaurants.
I told you that's never been her case. She's never said, she's talked of hugging in that. She talked of more difficult to police, more difficult to regulate. She did do that, but she's never denied that they will spread in casinos and restaurants.
My lord, my lord, but that's exactly my point. It has never been her case why she made the change. She's never explained it. Your lordship is completely correct. She has never given us a proper explanation. That's not her case. Her case, I'm not entirely sure what her case is, but on that very specific issue, she hasn't given us an explanation. There is no case in that regard.
Okay.
So my lord, I would argue that without a proper explanation for why she picked some winners over some losers, and here I rely on the papers of SANEF, where there were job losses, there were starvations, there were suicides, my lord. Effectively, income was cut off, and it wasn't for a limited period, my lord. It was the only reason that the total shutdown stopped is because we were in court the next day.
Is that the only reason?
Well, they haven't explained why else. Why suddenly change? Why do it the night before? Traditionally do it on a Sunday. Suddenly they do it on a Monday. In the absence of an explanation, they could easily have taken the court into their confidence, but they didn't. They haven't come to court and said, this is why we made the decision on Monday night. They haven't given an explanation. They need to take the court into their confidence. My Lord, we are in an era of accountability. We're in an era where they can't hide behind polycentric decisions and refuse to tell us really what they think. They gave us no medical evidence. We asked for medical evidence. We gave them 2 opportunities to do that. They didn't do that. They simply have kept their cards as close to their chest as they possibly could, and they have not. And this is where I must admit I feel hot under the collar. They had an opportunity to come and say, these are our reasons, this is what we relied on. We were totally legitimate in what we did. We thought about this very carefully. We had this medical opinion, that medical opinion. They haven't done that. They've tried to hide behind a veil of confidentiality, which, to be honest, my Lord, in light of the SO decision, is disrespectful to the judiciary and the SCA. So, my Lord, I would argue that in light of SO, instead of trying to debunk it, especially now that it's been confirmed by AfriForum, and if this was a government for the people, where they're happy to receive accountability, what an opportunity to place their case before a senior judge such as yourself. You go through their medical evidence, you go through what they base their decision on, and you say, these guys did a fantastic job, but they have ducked and dived and tried to hide behind mootness. They've avoided accountability at every turn in this matter. In fact, my learned colleague spent about 3 minutes on the justification of the limit and 2 or 3 hours on mootness. The case was procedural in nature. It was their opportunity to come and make a material case dealing with the material issues, and they've simply decided not to take the court into their confidence. My Lord, I would just like to pick up a few things.
I thought you said you're much quicker than your colleague.
My Lord, you said I would never have made such an allegation.
You're quicker than your colleague who's not here.
Yes.
And that
So
was news.
Yes. So, my Lord, if we look at the various issues that have been raised, my Lord, another issue, and your Lordship is well aware that I'm from Port Elizabeth or Kabeja. This issue, if I can just find it,
Find your issue, let Mr. Willis argue, we'll come back.
Just
people have been 2 hours in reply.
My Lord, if I can just if I can just share this page, my Lord, and this goes to the rationality of this decision. This is on 011/265 and paragraph 218. My Lord, when were the complete lockdown was instituted on the 28th of December. And this is very important. Nelson Mandela Bay was first declared a hotspot on the 28th of May, 2020 under level 3. My Lord,
you know that.
They
on Nelson Mandela Bay in answer.
Yes, but my Lord, they then reduced the restriction to level 1 in Nelson Mandela Mandela Bay until the second wave had peaked. This is, I would respectfully submit that this is not the actions, rational actions. This is, my lord, they say they send a team of Cuban doctors in November, 5 months after they declare a hotspot. With respect, I really don't think that we can argue that the minister acted rationally there. And she hasn't approached this matter in a rational manner, and it's because they've approached it in a polycentric manner, selecting winners and losers rather than using the DMA and the authorizations in terms of the DMA to fulfill the terms. I would respectfully submit that they've stretched the DMA beyond breaking point.
Thank you, Mr. Crompton.
My lord,
Side yours very much.
There's-
We're talking about what she did in other things.
There's
Mr.
one-
Crompton, there's nothing else.
My lord, there's one other point, is that I just want to raise the issue of foreign law and international law. My lord, we have a plethora of international and foreign law in our heads, and all of them have dealt with the matter, even though the governments all tried to claim mootness, and they're all lifted or recognize the freedom of religion and the ability and the freedom of churches to meet despite restrictions, and found that any restriction that you cannot absolutely stop someone from worshiping. My lord, I would be very dismayed if we were an outlier in international and foreign law. My lord, I'm going to hand over to my colleague, Mr. Willis.
Thank you. Mr. Willis?
Thank you, my lord.
Yes, the first time I've heard silk come after. So,
My lord, thank you, my lord.
hmm,
Lord, can I just ask Mr. Crompton to remove that shared document from the screen, if he would?
Mr. Crompton?
Lord, I would very much like to. I just don't know how.
Very well, I'll proceed.
My lord, I'll leave and come back. I don't know how to do it.
Mr. Willis?
Yes, my lord.
What is it? It's the first time I've heard silk come last, and after the juniors have already argued.
My lord, maybe it's the old adage of mopping up, my lord. I'm sure you've done a lot of that in your career, my lord.
Mr. Willis,
Yes, my lord.
let me hear what are the points you want to raise, and I want to raise.
Lord,
something.
I'm going to lead into costs, deal with costs with your lordship. Your lordship's heard me argue costs once before, my lord, so I know that it's not a matter that's foreign to your lordship in any event. My lord, I'm just looking for something here that I want to submit to your lordship that I made some notes on, and now I've lost my notes. If you just...
Well, so on cost, we know that what you call it one cost. We know Solidarity wants their costs. We know
Yes,
Mr. Buddha doesn't want his costs.
Everybody, Mr. Boda, as is proper and as he ought to have, disclosed to you what their arrangement is with their client. We, the rest of us, my lord, all seek costs against the state, and I submit properly so. But, my lord, your lordship could, of course, even decide the matter without. You could decide it in our favor and not order costs. And that's what I want to guard against, my lord, in my submissions to your lordship. My lord, there is no difference in the debates that have taken place between your lordship today when it comes to matters of freedom, and the sort of debates and arguments that had to be had in the 80s when there was a fight for racial freedom. My lord, religious freedom is what has been fought about for centuries and probably throughout the history of man. religious freedom, my Lord, is never moot. My Lord, no one thought that this matter was going to take 3 days before your Lordship. Why not, my Lord? Well, simply because on the papers, the issues did not disclose the questions that your Lordship has debated at length with my learned friends for the applicants. My Lord, and that is because, as Mr. Omar correctly emphasized and persisted with your Lordship, that this matter is determined on the pleadings. My Lord, there's a recent matter the Constitutional Court has just decided the last short while in relation to a doctor, a gynecologist, who went to jail. He was sentenced to 5 years. He only did 8 before he was released because it was set aside. It was set aside, my Lord, because the magistrate made findings premised on her own research and her own views and understanding of things. And my Lord, a man spent 8 months in jail. He's had to now forego he's decided to leave the profession. He would read in this case, I don't have it to hand, my Lord. I think he treated some 40,000 people, delivered 8,000 babies. And then somebody died under his care and he was accused of negligence. And he went to jail because a magistrate failed to exercise her function properly. And I say these things with the greatest of respect to you, because my Lord, what I appreciate about what your Lordship has done in this matter is you've done something that many of us have learned in our careers from seniors, and that is to test the case. One often sits in your client's case with your attorney, and halfway through the attorney and the client leave, and the client goes outside and complains that this advocate's not on their side. And all that counsel is doing is testing the case and making sure he understands it. Now, to the untrained mind, my Lord, it may look as if your Lordship is not open to persuasion. Of course, we know differently, my Lord. And your Lordship has pressed us and pressed us very hard. The reason your Lordship has pressed us hard is because we were not pressed in the papers or in the heads of argument. Your Lordship has pressed on a very, very important issue, because I know, my Lord, and I trust your Lordship, and I know I've argued matters before your Lordship, and I've argued difficult matters before your Lordship, that your Lordship intends to make the right decision, my Lord. But, my Lord, with the greatest of respect, your Lordship knows that, like that magistrate, you're not an expert in either casinos or in church-going.
Correct.
I know we all go to both, maybe at stages of our lives, but we are not experts in that. The minister's the expert, my Lord. The minister, and you've heard the submissions, and this all feeds into costs, my Lord. The minister, I heard your Lordship's debate, and I think it was good and proper that your Lordship pressed, especially the more junior members on this issue. It was good to see them squirm, my Lord. But the minister holds the power. Who she goes to for her assistance, that's her prerogative. But she carries the can at the end of the day, my Lord. She is the expert, my Lord, and we submit your Lordship. She failed to put you in a position to come to the assistance of the state. Even if you want to come to their assistance, my Lord, we submit with respect that you cannot. Now, my Lord, Mr. Omar was correct to argue the words of His Lordship, Mr. Justice Navsa, at page or paragraph 96 of the Liberty Fighters Network judgment. I watched the hearing. I, in fact, acted in one of the earlier parts of that case. And
is
Mr.
it
Omar,
or is it the court? I thought that was the court's decision.
That was a court decision, but NAFSA writes at that stage, my Lord, as I recall. But, my Lord, and we argued, Mr. Omar and I actually argued that case before the Constitutional Court more recently in the Muslim marriages case, my Lord. And it was seminal. It was seminal, my Lord, because, and there that was another religious freedom matter. And religion cannot be attacked. It cannot come under attack. We rely on a direct right. We do not rely here on an indirect right. We rely not on a convention. It is a direct right, and it is bolstered all the way down to section 9 of the Bill of Rights, dignity, my Lord. And the matter comes before your Lordship
Section 9 is equality. Section dignity, I think, is number 1. Section 9 is equality, I think. I'm not sure.
Yeah.
Section 9 is
My Lord, it goes all the way back down to dignity. And my Lord, the point is this. This is not the sort of matter that the minister could afford to come to court on without doing a proper job. Now, in what happened in the Liberty Fighters Network matter that came before Judge Davis initially was the applicants, Liberty Fighters Network and Mr. De Beer, put up a layman's case. My Lord, I know those papers. I argued the leave to appeal in that matter. I argued for Liberty Fighters Network. And there, Liberty Fighters Network, we were able to hold down half the case, and the rest of it was given with the Supreme Court of Appeal giving leave. And the reason Judge Davis took the approach he did was because he believed that the minister bore a greater onus, notwithstanding the paucity on the Liberty Fighters Network case. But when it got to the Supreme Court of Appeal, the minister came out on top because the Liberty Fighter Network case, notwithstanding, and I believe that this is correct, I believe this was a tremendous moment for one of our appeal court, our Supreme Court of Appeal, upholding the principle. It matters not whether you come as a layperson or whether you come by legal representation. The standards have to stay the same. And they upheld the appeal, and correctly so. Now, in this case, my Lord, the minister gets brought to court on 4 cases, properly established, properly set up. And my Lord, with the greatest of respect, my learned friend, Mr. Mokhagabe, a good colleague of mine, he does not take responsibility for these papers, and neither do his predecessors, actually, because at the end of the day, they are purveyors of their instructions. And the case that was put up in answer, my Lord, is an insult. It is an insult to the rights of probably the majority of the nation, my Lord. And they have not put your lordship in a position to find for them on the basis of your lordship's testing of our case and of their case, my Lord. The minister is the expert and she has failed. Now, my learned friend has just argued to your lordship that there's a pattern of this sort of behavior. And this is what brings us to costs, because what the minister did, instead of instructing our learned friends who have valiantly sought to carry out their instructions and make an argument for the minister, but what they've been forced to do, my Lord, is to try and squeeze themselves into a case which is not a case, where your lordship has sought to test the cases and test the issues so that your lordship steeps yourself in the issues. And they shouldn't have done that, but they've done that because that was their instruction. And they've tried to squeeze themselves into this case. It doesn't exist on their papers, my Lord. Your lordship is bound by these papers, unfortunately for them. Of course, your lordship knows that. I only say it because I must build my argument step by step. So notwithstanding Mr. Mokhagabe's courageous attempt to find a way through the back door into and create a case and hide the weaknesses of the minister's case, my Lord, I have to submit with great respect that my other learned colleagues, my learned friends for the applicants, have ably argued and highlighted to your lordship the weaknesses in their case. They cannot be hidden behind Mr. Mokhagabe's valiant efforts to put up your lordship's testing case to your lordship. My Lord, she's pitched her case, and like her decision, it comes up short. It doesn't pass muster. It doesn't pass muster in accordance with the rules that we all understand that are applicable in motion court matters. Of course, in motion court matters, your lordship knows. Your pleadings is your evidence. She doesn't answer the questions. My Lord, she doesn't answer the questions that your lordship poses. So, my Lord, in the result, submit to your lordship that your lordship ought to find for the applicants. And this is one of those matters, my lord, even if your lordship, for some reason in your lordship's mind, wanted to find for the state and did, for the minister and did, your lordship should still grant us the
I
costs.
wouldn't want to do that for the sake of it. If she has a case, I will. If
Yes, yes.
she's going to lose. Depends
That's
on
right.
whether there's a case.
Yes, and my lord, I've argued the following before your lordship before. Your lordship knows BioWatch. I just want my lord to focus on Harry Lowell's case. You'll
Which
recall
one?
the words, Harry Lowell's case, my lord.
Harry Lowell's case.
My lord, Harry Lowell's case is, it's 2017. I have the 2017 ZACC 38 as a citation. It may have been reported by now, it's been relied on extensively. And this is what was said in Harry Lowell. It said, although BioWatch was decided 8 years ago, it seems that the other courts are yet to embrace its principle. This is apparent from the growing number of matters that come before this court, this is the Constitutional Court speaking, of course, where the issue of not applying BioWatch is raised. This is unfortunate. In BioWatch, this court laid down a general rule relating to costs in constitutional matters. The rule applies in every constitutional matter involving organs of state. The rule seeks to shield unsuccessful litigants from the obligation of paying costs to the state. The underlying principle is to prevent the chilling effect that adverse cost orders might have on litigants seeking to assert constitutional rights, my lord. So, my lord, if for whatever reason your lordship finds against the applicants, I submit with respect that there is absolutely no basis on which your lordship could order costs against us. My lord, I submit that.
But Mr. Mugabe has conceded that.
My lord,
He
indeed,
doesn't want costs.
I didn't even hear that concession. My apology for wasting your lordship's time on that,
From
my
the
lord.
beginning, right at the end, he said, we asked for it in the heads of argument, but we're not seeking costs at all.
Well, my lord, I only knew what was in the heads. I missed that. My humble apologies. Forgive me for that, my lord. But my lord, in the result, my lord, I don't think it's absolutely
this question on the
yes,
cost
my lord.
question. And it's a question I'm going to ask you. It's two-part. If one finds that it is moot, I know there's a strong feeling that it shouldn't be found. And I'm going to be very careful before I make such a finding. But if one finds that it is moot, and you've heard the debate between myself and Mr. Karokia, it happens all the time that parties change at the door of court. It happens all the time. And then the issue becomes, well, then now you've changed last minute, you've compelled me for costs, compelled me to incur costs.
Well, my lord, you could order us the costs, my lord.
Yes, that's what I want to go to. But then, doesn't that mean that you only get costs up to the date that the regulations change? In other words, up to the date of the Part A application. Because you didn't get that. That wasn't that. Wasn't that. Because
Lord,
after that, the matter became moot. So the court found in their favor after that.
My lord,
not sure.
I hear your lordship. I hear your lordship, and I trust your lordship's not going to come to a finding that the matter is moot. But where your lordship
I had the same confidence.
Where your lordship
think very carefully about it.
Where your lordship
I'd like to deal with some of the merits. I'm very tempted to deal with the issues of executive action. I've asked the questions to Mr. Karolia. I hoped someone else would. I should have asked the question to Ms. Engelbrecht, and I'll ask it to you. I've asked that question. Look, how does one distinguish when it's executive and when? Because Mr. Mogabe urges me not to follow Esau, but to follow Mustert. And Lord, I said, if one was to go along that lines, one has to try and do more than just simply say, I accept Mustert. And I tried to ask this question, I did ask this question. How does one distinguish an executive action from an administrative action? And the easy answer would be the classical admin decision is taken by the admin person themselves without any other person interfering with or sharing parts of making that decision. slightly different in executive decisions. They tend to be a little bit more collective, not always, because a decision by a president is clearly an executive on his own, may clearly be an executive decision. So even if he takes it alone, it could still be so. But I've asked that question. I'd love to get into all those issues. But if I find that it's moot, then I'm unfortunately deprived of that benefit opportunity. Is that correct?
My Lord, let me answer just comment on the first question you pose. It is ordinarily, or it is often, a vexing question, or it can be a vexing question, whether something is an administrative decision or not, my Lord. But my Lord, it's not that is not something you are truly challenged with in this case. Why, my Lord? Because once again, it is not on the papers. The minister does not come and make that case out, your Lordship. Your Lordship, with respect, has tested the case with that thinking of your own, my Lord. It is not their case with respect.
Look at her case. She says, when she talks, she just talks about exec action and others.
But my Lord, it's the same in an environmental law matter, where the HOD or the MEC makes a decision. They take into account the evidence and information of experts.
Yes,
but it is not an executive decision.
No, I understand that. I understand that you receive inputs. I gave the example of the pricing committee in the new clicks matter. And I think the environmental matter, you're probably the one that you said you appeared before me.
That last one I did in front of you, yes.
Eagle matter or something.
We're on our way, hopefully, to the Constitutional Court. Then,
I understand, yes. I understand you lost in the...
But thank you, but thank you for the results you did give us in that matter, my Lord.
Well, did you win or lose? I'm not sure. But the SCA threw out the appeal, I know that. But let's just stick to our point. So yes, you take advice from a party when you make your decision, but it is your own decision. When somebody else is sitting with you and making that decision as well, or sharing the making of that decision, in other words, not disadvising you, but could be the one that takes the decision. In other words, the minister doesn't take this decision alone. It's actually a decision taken by the cabinet.
My Lord,
is that not indicative that it's more than admin action?
I think I can help you with one perfect example and why that thinking that your Lordship is propagating is not correct. And it's this, my Lord. There have been now probably endless number of cases that have been brought against the COGTA minister. Your Lordship will not find one judgment where the NCCC had to be cited. It was cited initially in some of the cases. The NCCC is not a party that has a legal interest in any of these matters. It is only the COGTA minister, and where she takes a decision that might affect another department, they are joined as a matter of caution. But my Lord, there is only one minister in this phase of the history of our constitutional democracy that you're going to run into trouble if you don't join her, and that's the COGTA minister. There are situations where you don't have to join her. I've been in at least 2 cases where we didn't have to join her, even though it was COVID related. But my Lord, if there's justification to join the NCCC, then they would have, because that is
it's not the NCC, it's the president, isn't it?
Well, no, my Lord. No, my Lord. Not even the president.
The cabinet decision, she said.
These are not cabinet decisions, my Lord, at all.
Well, what was Mr. Mugabe reading then?
My Lord, these decisions vest, according to the statute, entirely in the hands of the COGTA minister.
Ms. Engelbrecht, I've noted you. Ms. Engelbrecht, I've noted you.
Thank you very much, my Lord. I put up my hand not to interrupt, but as a placeholder, since your Lordship said that he ought to have asked me the question, and I wanted to indicate that I would very much like to take up the invitation afterwards.
No, I will ask
to answer that question.
No, I was going to ask you the question anyway.
Yes.
Okay.
But I will wait until Mr. Willis has completed his address.
Mr. Willis?
So, my lord, the authority vests in the COGTA minister. This is not a matter, my lord, where where this power is shared, or she could. In fact, I'm not even certain she can even delegate, my lord. I haven't applied my mind to that. These are her decisions. She might take them under advisement. In fact, she ought to. And this is part of the problem in this case. She puts up no evidence to show you, my lord, scientifically, and the courts have spoken to the science repeatedly on these cases, to show you, my lord, why clapping is an issue, or why churches are an issue, my lord. This whole economic argument that your lordship has tested with and proffered, respect.
Mr. Willis? Mr. Willis, can anyone hear me?
Yes, Judge, we can hear you.
Yes, my lord.
Mr. Willis?
Can hear you, my lord.
Can you hear me, my lord?
Yes, now.
Am I back? So, my lord, just to repeat that, it's part of the problem in this case, is that this argument around economical interests, such as your lordship has put the questions, has not been fleshed out in the minister's case. And had she done so in her papers, my lord, there would be scientific evidence. Her decision is irrational because
What scientific evidence would there be?
My lord, sorry?
What scientific evidence?
Well, my lord, she notionally tells your lordship, or mentions, and that's the high level mark of her case, that people clap in church. Or people clap in a lot of places. People drink alcohol in casinos. Now, my lord, where is the scientific evidence to demonstrate to your lordship, or the sociological evidence to demonstrate that churchgoers are less worthy of their rights than economy? I mean, are we going to get into a debate between the poor and the wealthy? So, my lord, with the greatest of respect, that's the problem in this case, is the lack of evidence, because I submit, your lordship, on the probabilities, and one doesn't measure this evidence on probabilities, but in as much as you want to consider the possible answers, if there was evidence, she would have put it up. If she did take this decision in a collection of people, she would have put it up. My lord, this is an administrative decision. By no stretch of the imagination is it executive, my lord. I submit with respect, and it's good that your lordship tests it, but that is a ruse of an argument by the state, my lord, that this, just like the moot argument is, as has been submitted to your lordship. Lord, I don't have too much else to say, save, of course, anything your lordship might ask of.
Nothing. I want to give the floor to Ms. Engelbrecht.
Indeed so.
Ms. Engelbrecht.
Thank you, my lord.
As it pleases the court, I won't take long in answering the question
One
that your
thing you've
lordship
learned, I must say, you've never taken long. You've been succinct always, Ms. Engelbrecht.
Lord, the starting point of answering the question about whether this is administrative action is section 27(1) and 27(2) of the Disaster Management Act, because that is the source of the power of the minister. And we see in 27(1) that in the event of a national disaster, the minister may, by notice in the Gazette, declare a national state of disaster, and the circumstances in which she may do so are set out. In other words, she is not given a wide discretion. She has to only do that within the circumstances contemplated in 27(1)(a) or B. And then 27(2) says, if a national state of disaster has been declared in terms of that subsection, the minister may, subject to subsection 3, and after consulting the responsible cabinet member, make regulations or issue directions or authorize the issue of directions concerning, and then there's a variety of matters. Now, we know that the minister here is the responsible minister, is the COGTA minister. That's the minister that's been delegated with this particular authority. But what the section makes absolutely clear is that she issues these regulations or directions after consulting the responsible cabinet minister. So, for example, the DTI minister in relation to something concerning trade and industry and the like. But we know, and your lordship will be well aware of the case precedent concerning interpretation of what is the duty after consultation, in consultation with, etc. Here, what is required is that there may be consultation, but the ultimate decision made here is the only responsible person, in terms of the clear language of the statute, is the minister herself. She is the one that takes the decision, and she takes decisions that in paragraphs, I think it's 33 to 35 of the AfriForum judgment in the Supreme Court of Appeal, 33 to 34, makes it very clear that this decision-making is it's a bureaucratic process. It's the minutiae of how we regulate, the minutiae of how we decide. It's not simply a matter of making a policy decision that there should be restrictions. What is being done is that delegated legislation is being passed to give effect to the policy after consultation with the cabinet minister. It is now bureaucratic. And I must make this point. From the line of cases that starts with Harris, the education case, and which is confirmed in the AfriForum case, when a minister or a party invokes a power that it has in a general sense in order to justify that which it has done, although previously it invoked another section, that's not a proper justification. The bottom line is this: if the minister here has gone beyond her powers, under 27.2, she's ultra vires and therefore can also not justify. So either she must accept that this is administrative action that is governed by 27.2, or she falls short because she wants to rely on a broader power than the bureaucratic powers that were afforded her under the Disaster Management Act. Those are our submissions in that regard.
Thank you. Thank you. Thank you. Ms. Martins, is there anything you want to say on this issue?
No, thank you very much, my lord. I think it's been well captured. Thank you so much.
Does everyone agree that if there's a finding of mootness, I'm not sure it's going to be taken so lightly, but assuming there is, then one avoids answer. One no longer has to deal with the rest of the case. That was Mr. Mokhakhabe's submission. Is that right, Ms. Engelbrecht?
My lord, if I may say this, it is of course in principle correct that if the court can dispose of the matter by adjudicating it on a single point, it is open to the court to do this.
But there is strong authority, particularly you see a lot from Innes and you see it by Corbett and others who say, please don't go any further.
Yes.
There's a long authority, and that's what he meant by catered question.
Yes. But there are also indications in a later and more constitutional era that it might be of a benefit. In this case, what your lordship is faced with, and is what your lordship recognizes, is there are important matters relating to whether it's executive action or administrative action and the fundamental right to religion. And for example, in the case like I want to call it the Masters Policy case, that concerned, it came before his lordship, Mr. Acting Judge, Justice Katz in the Western Cape High Court about the allocation of insolvency practitioners according to race. And the matter went through the Supreme Court of Appeal and ultimately to the Constitutional Court. And in a matter like that, his lordship, Mr. Acting Justice Katz, recognized that even though the matter could be disposed of on one point, in a matter where the expectation was that higher courts might be called upon to adjudicate on the matter in due course, it was helpful that all of the arguments that were presented were dealt with in the matter so that the higher courts could engage with those findings in addition to as it were, the main point. So we would submit that your lordship might be guided by that, although it is open to your lordship to make a finding on a single issue here. The expectation that the matter will go further, given the importance of the case, suggests that your lordship should engage with all of the arguments that have been placed before you, so that any court that might consider the case in due course has the guidance of the thinking.
Yes, thank you. Thank you all. Thank you. Is there anybody who wants to say anything? Is there nobody who wishes to say anything? Well, in that case, judgment is reserved.
Sorry, my lord. Lord, might I, on behalf of the applicants as well as the respondents, thank your lordship for your patience over the last 3 days. We're indebted to your lordship. Thank you, my lord.
Thank you. Thank you. If there's no one else who wishes to say
Well, my lord, I want to say that also I convey the legal team's appreciation in dealing with the matter, particularly in giving the applicant's counsel more latitude in reply to ventilate matters which in practice and in terms of the rules they were not supposed to. They started to rehearse their case, my lord, but we appreciate that, my lord. You have given them more than sufficient opportunity and time, my lord, to ventilate their case. And we laud you for that, my lord. And we thank you for conducting the case and having to bear with us, my lord, and bombard you with so much information for 3 days. But we all say, my lord, we handle the matter well, my lord, and that that's it, my lord.
Thank you.
Even there's something I want to say, my lord. I trust that Mr. Willis, as a senior counsel, when he made that submission, that in the presentation of my case, I did my valiant best to hide the weaknesses of the respondent's case, that he was not impugning my integrity or casting aspersion on my dignity and integrity and character.
Thank you.
Absolutely. Lord, might I assure both you and Mr. Mokhagabi, absolutely not.
I know that. I know that. Thank you, Pedro.
It is his skillfulness to which I allude, and by no stretch of the imagination would I ever cross that. You couldn't accept that from me. Thank you, my lord. Thank you, Mr. Mokhagabi.
Thank you.
Thank you, my lord. Thank you, Mr.
Nothing else?
Nothing, my lord.
Thank you. Then judgment is reserved and court is adjourned.
Thank you, my
will
lord.
get
As a court
judgment in
pleases.
due course. I don't know how long it will take. It's quite a lot of reading to do.
As your lordship pleases.
If I finish early, I'll give it to you as soon as I'm done.
As a court pleases, my lord.
Thank you.
As you please, my lord.
Thank you all for your time. Court is adjourned.